Right. 2 seconds. First. How are you? You got everything ready as well? Sure. You got a print out there for me? So many bloody papers. Yeah. All right, cool. Thanks. Let's get myself sorted out. Let's kick off. All right, good morning, everyone. I now declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Cybersecurity Legislation Package 2024. Now, these are public proceedings, although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege unless you are giving evidence from outside of Australia. It is also unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. In accordance with the committee's resolutions of the 7th of September 2022, this hearing will be broadcast on Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. The hearing today is being conducted with some members of the committee and witnesses appearing by video conference. Members and witnesses participating remotely are reminded to mute your microphones when you're not speaking. Anyone else in the gallery, please switch your phones to silent. I'd like to now welcome our first witness for today, representative of the Australian Information Security Association, to give evidence at our hearing. Good morning. Good morning. For the Hansard record, could you please state your full name and the capacity in which you appear before today's hearing?
Good morning, Chair. My name is Akash Mittal. I'm representing as the Chair of Australian Information Security Association today.
Excellent. And thank you for that. Now, although the committee does not require you to give evidence under oath, I should advise that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of respective houses. The giving of false or misleading evidence is a serious matter, may be regarded as contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Due to the very short time frame that the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability in evidence today, which I'm sure you will. And as further written evidence, further written answers will have to be provided within 24 hours if you do take anything on notice. Now, I'd like to invite you to make a brief opening statement if you've got one.
I have, yes.
Yep, before we then proceed with questions from members. So please proceed with the opening statement.
Sure. Thank you, Chair, and members of the committee for the opportunity to address this inquiry. My name is Akash Mittal and I am the Chair for the Australian Information Security Association, or AISA as we call it. AISA is Australia's peak non-for-profit body for cybersecurity professionals, representing over 13,000 members who work across various sectors to safeguard the nation's digital landscape. Our members, ranging from private industry to government entities, contribute their expertise to improve Australia's cyber resilience, and they continuously work to protect the digital security and privacy of Australians. We see digital security as a public good, one that requires robust partnerships between the government, industry, and the community to ensure everyone can benefit from a secure online environment. AISA's mission is to support the cybersecurity sector through workforce development, public outreach, and advocacy. We advance digital security by offering training, holding knowledge-sharing session events and national conferences, conducting research, and providing free resources that help Australians understand and manage their cybersecurity risks. Through these efforts, we aim to foster a resilient digital ecosystem and a strong, skilled workforce that underpins it. Over the past year, AISA has engaged extensively with its members and the broader industry to provide inputs into the cybersecurity legislative package. Our submission is based on insights gained from town halls, roundtables, and surveys conducted across our membership. We are encouraged by the positive steps this legislative package represents and the collaborative approach taken by the federal government and the Department of Home Affairs in seeking industry input. AISA supports several key components of the package, including the introduction of the minimum security standards for smart devices, establishing a cyber incident review board, and the mandatory ransomware payment reporting. We see the benefits of implementing minimum security standards for IoT devices, which will ensure a high level of protection for consumers. However, more needs to be done to inform consumers about these standards and to ensure they understand how to keep their devices secure over time. Our members suggested that simpler, more accessible update processes would help improve compliance with this requirement. The Cyber Incident Review Board will increase transparency by conducting post-incident reviews, which can help identify lessons learned and improve future response strategies. However, we do want to note that members have expressed concerns regarding how the board will be formed and who will be invited to join as an expert on these panels. AISA suggests addressing these concerns by us assisting the government with sourcing experts who could assist as independent reviewers and maintain a pool of resources for the board. In addition, the introduction of the mandatory reporting of ransomware payments is an important measure. While most respondents to our survey supported this obligation, there were some reservations about the 3 million reporting threshold. Many small to medium-sized businesses, which can be significantly affected by ransomware, fall below this threshold. AISA believes that offering these smaller organizations the option to report voluntarily will help broaden our understanding of ransomware's impact across the economy. One area of caution for us is the limited use obligation, which has generated uncertainty among our members. Although this provision intends to reassure organizations about the scope of information sharing, the limited use requires further limit of scope to address sharing of information for intelligence or legal liabilities. Organizations worry that data they share voluntarily could later be used for enforcement actions. We recommend clearer guidelines for this provision to promote greater transparency and willingness from organizations to share incident data. In conclusion, we believe the cybersecurity legislative package is a positive step forward in protecting Australia's digital landscape. AISA is committed to assisting the government in refining these measures, addressing any potential impacts on businesses, and ensuring a strong, resilient cybersecurity framework for all Australians. Thank you, and I look forward to discussing these points further with the committee.
Thanks a lot for that, and do you mind tabling that opening statement? Yeah, sure. And we'll get a copy sent around to committee members for their benefit as well. Okay, well, look, I've just got a few questions before I hand the call around. Could you just maybe discuss why your members rated the benefits of having the security standards, the IoT security standards, as so beneficial to the cybersecurity of Australians?
Chair, we believe the responses that we receive from our members, in regards to the three measures that are going to be applied as part of the minimum standards for smart devices, enables them with not worrying about the default passwords or how the vulnerabilities will be managed if there's an issue with one of these devices, or how these devices need to be consistently updated to keep them safe and secure. And those three minimum standards provide a very strong baseline in terms of giving our members the confidence in terms of the proliferation of IoT devices into their day-to-day lives and use of smart devices. It gives them the comfort of that these devices will be protected through these measures, and they won't fall victim of cybersecurity incidents where an incident occurs because use of default password, or because there was a known vulnerability which was not managed properly, or there was an update required to a device and it was not, updated in time by the manufacturer. And
in terms of the benefits, what are the benefits for Australia having a cyber incident review board?
Look, I think the members, the response that we got from the members is they appreciate the effort in terms of having a board, an independent board, reviewing incidents that are of public interest, are related to national safety, and to be able to understand what really transpired. How can we learn lessons and build better response strategies beyond those incidents to then use those learnings to make individuals, businesses more cyber resilient?
And with respect to the board, obviously the bill doesn't set who would be members of the board, but who would you be able to provide as some indication as who you'd like to see as composing the membership of that board?
Sure. Chair, it depends. There's a number of factors that need to be considered. The type of incident, the impact due to the incident, the industry that incident has affected, and the kind of skills you need. The skills range from technical to privacy to regulatory requirements to operational understanding of these businesses and so on and so forth. And I think that's why a very diverse pool of experts are required to be able to come on this board and the expert panels. Depending on each situation, each incident, these experts then need to be invited to join the incident review board to then understand the intricacies of what happened, how the incident was managed, from an issue management to incident managed to if there is a crisis management.
And I understand the consultation with government to date has been quite extensive, and I think you and your members have been pretty happy, it's fair to say, about the level of consultation. Could you please explain maybe how you've been engaged by the department on the reforms since the launch of the cybersecurity strategy back in December 2023?
Yeah, look, Chair, I think we are pretty happy with the engagement from the department. We got engaged and involved quite early on in December in terms of the next steps and in terms of what the legislative package would look like. We had a number of interactions with the department, with the Office of the Cybersecurity Minister. We were also very fortunate to be able to organize some roundtables where the department actually attended those town halls and the meetings with cybersecurity industry professionals to have a very robust, open conversation about what the bill and its components and initiatives need to look like. It's sometimes it is very helpful to have that sort of access within the department and with the government to understand the intricacies of the bill, the language that comes out, to understand what it really means and where it's going to affect or impact the professionals on the industry. In my experience, the engagement's been really, really good throughout with the department. We were not surprised when the draft bill came out in terms of the inclusions. It was communicated really well.
And what benefits do you also see of the amendments to the saki to Australia's cybersecurity?
Look, I think in terms of the amendments to the saki reform, the critical data, I think it's required. It's important. The data storage systems, they are crucial to businesses who are supporting national infrastructure, and it is important that those data storage systems are protected, and particularly where there is a third party who's involved in managing. So that's supported, and I think our members are very supportive of that change to the saki Act. In terms of the all change of from cybersecurity incident to all hazards, there's some concern there in terms of the member feedback, It's a mixed feedback in terms of what that means and what that could look like. It's a positive step forward, particularly to be able to have government step in and help affected entity that is of national importance and where the entity is unable to manage the impact of an incident. But the feedback that we've received, it also shows that the members believe that it needs to be a coordinated, collaborative effort to manage the risk. There's a lot of context, when you're dealing with an incident like that in terms of, the operational context, the tech context, and that's why it needs to be more of a collaborative effort. The another feedback we've received is who will be responsible for the risk if there are any risks that are induced as part of the government stepping in. Beyond the post the incident, who will be responsible for those risks if there are any that are introduced as part of managing the incident? The another question that also remains a little bit unanswered is in a situation like that, what happens with the entities that are part of the ecosystem and supply chain for an industry, for a business that is part of the SOCI Act, but then these entities are not part of the SOCI Act? How that's going to be dealt and managed during an incident management where the government decides to step in. Information sharing across the industry and government, again, I think that's supported. It's better explained now in terms of the information that needs to be shared between the government and the industry. Power for government to address serious deficiencies through the Critical Infrastructure Risk Management Program. Again, that is supported well. These businesses, if they are under the SOCI Act and they hold national infrastructure or are critical to our infrastructure, then those deficiencies should definitely be addressed as part of the risk management program.
And I'm assuming part of the process of the consultation, you've flagged some of these concerns or questions to the government about...
Yes, yes, we have. Yes, we have gone back with the response.
And in terms of ransomware payments, I understand your members are supportive of the ransomware payment reporting obligations being introduced. Is that correct?
Yes, that's correct. The survey tells us that was the most supported initiative out of the bill from the members.
Yeah.
However, we do note the concern around the possibility of the group that possibly is most impacted, which is the small, medium-sized businesses, or the non-commercial entities that are not included in the reporting requirements. That could be, we might be missing a big data set of how they are affected by the ransomware attempts, or when there is actually a ransomware and they had to pay a ransom.
So that's the threshold, correct?
Under the threshold of $3 million, yeah.
Because I wanted to ask you about that. I think it's, $3 million,
that's right.
The threshold.
Yeah.
Do you believe that needs to be altered, that level?
I think, yes, we believe that it should be altered in terms of the organizations or businesses which are below the threshold. There needs to be some support from the government in terms of helping with that reporting. And it should be more voluntarily done, but encouraged by the government, because we believe that we're missing a good part of the economy in terms of understanding the effects of ransomware.
I mean, as I understand it, I think that figure, 3 million, aligns with requirements in the Privacy Act. So, and I think that's, for consistency, I think does make some sense. But I just was interested to understand, if we were to leave it at the $3 million figure, what other mechanisms we could look at potentially to make sure that people, whether they're on $3 million and $1 or $2.9999 million, what the difference in their obligations.
I think there needs to be, beyond that point, I think there needs to be a risk lens applied. What's the risk to these entities, like non-commercial entities? You look at non-for-profits and charities or think tanks. What's the risk what value or data information that they are holding that they will be target for a ransomware? And if that happens, what's the risk to the organization, to the customers or people who they're supporting, or to the nation overall?
Okay. Now, last question before I hand over to the Deputy Chair. Just to pick up what you said earlier about the consultation process. I mean, I know we've got a very short period to report back to the Parliament, but given the extensive consultation that you've had, I take it you're not surprised by what's been put on the table in terms of the bills before us today?
No, we're not surprised by the inclusions of the bill. I think there are elements of the bill where there's further awareness and explanation of how the implementation needs to happen, and this is where again we invite the consultation and collaboration with the government to then work on that next step of going how that could be done in a way that we manage and look at all the nuances to make sure that we don't make mistakes through the implementation of some of these inclusions.
All right, well, thank you very much, Akash, for your time. Now, I'll hand the call over to Mr. Wallace. Mr. Wallace, are you online?
I certainly am, Chair, and I'll try and refrain from leading the witness. Thank you very much, Mr. Mittal. Have I got the pronunciation correct there?
Yes, you have.
Thank you. Just in relation to the ransomware reporting, the Chair took you through, your views around the appropriateness of the $3 million annual turnover, and you talked about in your view, you were invited to give some remarks around whether the $3 million threshold is correct, too high, too low, and you said that it should be more addressed through a risk-based approach. But so that causes me some concern, because ransomware, as I understand it, is not just demanded of companies that might be regarded as high risk because of the sort of work that they do. So I'm just wondering if we adopted your risk-based approach, how efficacious that might be, given the sort of scattergun approach that is often taken to these things.
I think the introduction of the threshold of $3 million, I think, gives a good large set of data in terms of the coverage provided across the businesses. But there should still be efforts beyond that point to then apply a risk lens in terms of one of the issues with the ransomware is it's a combination of these threat actors going after companies who they believe have got sensitive information for which, when they hold them for ransom, they will pay the money to release the information of the data. So in that regards, that's where the risk lens needs to be applied in terms of what organizations below that threshold will be storing or will have information or are part of the supply chain, which could affect organizations which are part of the SOCI Act, or other organizations which could be impacted by them being impacted by ransomware like a attack. And this is where we're suggesting that a risk-based approach should be applied, and then have another subsection below the 3 million threshold to identify these organizations which are non-commercial or non-for-profit or charities, and so on and so forth.
Okay. I'm going to try and get through as many questions as I can. So if you're able to keep your answers as tight as you possibly can, I'd really appreciate it. Given the obligation only applies when ransom payments are made, not when they're demanded, do you think there needs to be a floor on annual turnover at all?
Sorry, can you repeat that question, please? Sorry.
Sure. Yep. Given the obligation only applies when ransom payments are made, not when they are demanded, do you think there needs to be a floor on the annual turnover of the business?
Yes, we believe so. That's right. In terms of through that we're not capturing the unsuccessful events.
Mm-hmm. Okay. Once a payment is made, the ability of government to assist in any meaningful way is likely past. Do you think the reporting obligation should apply before a payment is made? For example, when the ransomware attack originally occurs, or a declaration of an intent to pay prior to payment occurring. Does that make sense?
Yes, it does.
Yeah.
Deputy Chair, is it okay if I take that on notice and come back with a response?
Yeah, sure. Absolutely. Yep, that'd be great. Thank you. Under what circumstances, if any, would you contemplate making, and this is not directed at you personally, but more in your capacity as the chair or of your member organisations, in what circumstances, if any, would you contemplate making a ransomware payment?
I think where there is human life is at stake, or matter of national security. I think those are the two that I can think of on spot at this stage where would consider, paying a ransom.
Okay, thank you. Do you think there's a risk that instituting a mandatory reporting regime could be perceived to legitimise the paying of ransoms as an appropriate response to a cyber incident?
No, we don't think so. We think at the moment we don't know the quantum of the problem, and this will allow us to get our hands around how big is the problem first, to be able to then go down the path of what are the strengths, resilience that we can build in our environments to sort of throttle these threats away, and then sort of maybe have a robust discussion around whether these payments need to be legalized or otherwise.
Okay. Could the $3 million annual turnover threshold for reporting incentivise malicious actors to target small businesses? And I suppose that comes into your risk-based approach that you were talking about earlier.
No, we don't believe so.
No? Okay. All right, thank you. Just in relation to the minimum standards for IoT devices, how prepared do you think industry is to implement mandatory security standards for IoT devices should the bill be passed?
We believe through our conversations and the surveys and the roundtables that we have done so far is that there's a lot of work that needs to be done in that space. Again, the implementation really needs to be thought through. The one concern that has already been raised with us is the fact that there's a lot of devices that are already in the consumer base today, and if this bill applies as of when it's passed to any devices manufactured from that day onwards, we still carry the risk of the devices that have been in the consumer base over the last few years, and until they're sort of phased out of the environment.
So can I just clarify that,
Sure.
that answer? So the way that this will operate is that there'll be a commencement of the requirements of these devices to comply. Is there a grandfathering provision for? There would have to be a grandfathering provision for goods that are out there at the moment, but what about goods that are out there in the shops but haven't yet been sold?
I will take that on notice, Senator. I don't believe that is the case at this stage, from what I can recall. There is a implementation date as the bill passes, and any devices that are then sold in the consumer base from that day onwards.
Okay. Just hang on 1 second for me.
Sure.
In the event that manufacturers of low-cost devices opted to exit the Australian market due to the additional compliance burden, is there a risk that Australian consumers will opt to buy the same devices from intermediary overseas businesses without the protections that would apply in the Australian market, do you think? Yes,
that is a fair point, and we have called it out in our response as well, is if the cost for the consumer is going to go up because of this minimum standard requirement, then there is better controls that then need to be placed in terms of the consumers buying these devices overseas and through various platforms and websites.
Chair, I'm conscious of the time, and I'm conscious that I have many other questions which I can probably put on notice, but I'm conscious also that Mr. Gosling and Ms. McKenzie probably want to ask some questions as well. So if we've got time, you can come back to me, but if not, I'll put them on notice.
That's all right. Look, I think we have, well, we do have some time, and unless Mr. Gosling or Ms. McKenzie let me know they've got any questions.
Happy for the Deputy Chair and yourself to keep going at this stage. Thanks,
Yeah, that's what I thought.
Great.
Just keep going, Andrew. You've got the call.
Great, thanks, Chair.
Sorry, Mr. Wallace.
In relation to the limit... Yep. Did you call me Chair, did you?
No, I called you Andrew, but Mr. Wallace, you have the call?
Oh, sorry, Chair, thank you. I don't know whether you can see me. My camera's playing up a little bit.
Oh, we can see you, and your lovely views in the background.
Yes, the Sunshine Coast it's a magnificent place. Now, Mr. Mittal, just in relation to the limited use obligation aspect, the explanatory memorandum states information provided to the National Cybersecurity Coordinator under the obligation with respect to the entity's actions relating to the cybersecurity incident is not admissible in regulatory proceedings against the entity to the extent possible, unquote. Are there any circumstances that you're concerned about where information provided under the limited use obligation could be used in legal proceedings?
If I recall correctly, Mr. Wallace, it does mention the legal liabilities under the civil penalties. If there's information that is shared as part of that incident with the National Cybersecurity Coordinator, that could then be used as an evidence. And I think that's where there are concerns.
Okay, do you want to expand on that a little bit for me?
So as I understand, the information related to a cybersecurity incident shared with the National Cybersecurity Coordinator's Office is purely for the purpose of the incident and can be shared with other regulatory bodies purely around a cybersecurity incident, but exempts from any civil penalties and legal liabilities if there is information that sort of falls under those legislative requirements.
So are you drawing a distinction there between a regulatory action by the regulator and civil proceedings that might be brought against a company?
That's right.
Does that cause you or your members any concerns, or do you think that
It's a confusion, and I think it's the clarity that's more required. And if I refer to the survey, when we asked the question, how comfortable members feel in terms of using this and engaging with the National Cybersecurity Coordinator's Office in a situation of an incident, we got mixed feedback. More than 50% of the respondents said that they don't feel comfortable or they need more information. And I think this is where the clarity and the awareness is required in terms of what that will mean and where the line is really drawn from a sharing of information. Similarly, what sort of information will also be shared also needs to be defined clearly. If we're talking about telemetry, triaged, technical log information, then that's very different to, sharing your data information with the coordinator's office.
Okay. I don't know how familiar you are with actually, you know what, I'll take this question on notice because I think it's unfair to ask it of you orally. So I'll ask that question on notice. Do you have any concerns about circumstances in which information was provided under the limited use obligation could be used in legal proceedings or in any way that would be perceived as detrimental to the disclosing entity? It's a related question.
I will have to take that on notice, Mr. Wallace.
Yeah.
So you basically on that you asking for like a scenario or an example.
Yes. Okay. Moving on to the Cyber Incident Review Board, do you think the provision for the Minister to approve the terms of reference for any review conducted by the board will undermine the board's independence?
I believe the whatever the outcome that comes out of the CIRB should be in public domain and should be shared, as part of what is being investigated and what comes out of their investigation in the public domain.
Yeah, I'm not sure. I'll ask the question again because I don't think that quite answers the question. Do you think the provision for the Minister to approve the terms of reference for any review conducted by the board will undermine the board's independence?
When you say terms of reference, is it the terms of reference for the composition of the board, or the
for a review, for any review conducted by the board?
Sorry,
so effectively, the Minister will have a right of veto over what the board investigates.
Yes.
And
yes.
To perhaps to some extent how it does that.
Yeah, no,
do you think that,
thank you. Sorry.
Do you think that has the potential? I'm not sort of looking at any one particular minister. When we design legislation, we always try and look at how this will operate under blue shirt, red shirt, doesn't matter what shirt it is. We need to make this legislation, as efficacious as we can. And I just have some concern about whether that the minister's right or ability under the Act to call the shots in the terms of reference will undermine the independence of the board.
Yeah, the answer to that is yes. It needs to be as independent as possible in terms of CIRB doing and conducting its own investigation, the way it wants to proceed, and the way it wants to then find the findings to present.
So would you prefer to see a situation where the minister doesn't have that power?
Yes.
Yeah, okay. Thank you. Do you have any concerns regarding information sharing with the review board, particularly around confidential or sensitive commercial data?
Yes, we do. We do have concerns in terms of the powers that the CIRB can have and to what that power will extend in terms of seeking the information during an investigation. The another concern that sort of stems out through that is there a possibility of that information then being shared with any other entities or agencies for cross-reference checks? And again, this goes back to the feedback that we've received from our members is the composition of the CIRB for that very reason is very important in terms of representatives from regulatory bodies, agencies, or law enforcement agencies. It needs to be managed in a way that it manages its independence as much as possible from the minister or the regulatory bodies in every way.
So, what's your understanding of the way that the bill is currently drafted as to how that information could be shared? Is it your understanding that it could in fact be shared with other agencies, or you're not sure the way it's currently drafted? No,
okay. Sorry, Mr. Wallace, we're not sure.
Okay, so you would say that needs to be tightened up, assuming.
That's right.
Okay. Thank you. You're doing very well. Thank you very much.
Thank you.
The explanatory memorandum notes the standing. The explanatory memorandum notes the standing members of the board will be members of the public service appointed by the minister. Do you have a view on whether the board's standing membership should be restricted to APS employees or whether it should have a representation from industry?
I think it again goes back to. I think, and this is where AISA thinks that it can help in terms of vetting, those board members and expert panelists coming on the board. I think it depends on a number of things: the powers of the CIRB, the incidents that they will be reviewing, and the kind of skills, knowledge, backgrounds that's required. We think that it's a combination of people from the government, probably the academic industry, and possibly APH to come on board as a collective team to be able to then contrast their learnings, their knowledge, their backgrounds when looking at incidents of public interest.
Mm-hmm. And at the moment, it's just restricted to APS employees. Is that right?
I'll have to take that on notice, Mr. Wallace. I'm not sure.
But in any event, you think it should be APS, industry, and academia?
That's right.
Yeah. Okay, good.
Yeah, experts, experts from the industry. Sorry.
Are we due to finish up now, Chair?
Look, we are, but I can give you another few more minutes, mate, if that's what you need.
You are a very generous man. Thank you. I'm not used to such generosity.
Oh, that's
Thank
okay.
you.
I'm glad that's on the record. Just if Peter's watching.
Do you know what? I don't think you will be.
No.
In relation to the Cybersecurity Bill, the Intelligence Services and Other Legislation Amendment Cybersecurity Bill, the explanatory memorandum states both industry feedback and ASD's operational experience indicates a declining willingness from entities to share technical cybersecurity incident, network telemetry and vulnerability information in a timely fashion with ASD. Has this been your experience, Mr. Mittal, and what do you think is driving this decline?
Yes, we believe so. From the feedback that we've received from our members in the industry, there is still a CIRT, which is a threat intelligence platform made available through the Australian Signals Directorate. There's a number of reasons behind that, in my opinion. One, we think it's not been made away, within the industry. The information sharing is one way as well in terms of that telemetry.
What you mean. I'm not sure what you mean by that.
In terms of the platform, the threat intelligence information.
Your last answer,
Sure.
last sentence, I just didn't quite understand what that meant.
Sure. So the information is where the industry provides the information with the Australian Signals Directorate, but what information they receive back from the Australian Signals Directorate in terms of the threat intelligence is limited, and I think that's where there's more efforts that could be done.
So can I just interrupt? Sorry,
Sure.
Can I just so I understand your response? Your members are suggesting to you that there is a reluctance to report to ASD because the feedback from ASD back to that reporting business is sometimes not up to scratch. Is that what you mean?
No, apologies, Mr. Wallace. I was more talking about the threat intelligence information. But in terms of the incidents as such, I think there needs to be better collaboration between the ASD and the industry. And I think there are concerns around the data sharing. And I think this is, again, why this limited use obligation is a good step forward. It again comes down to the awareness and the clarity. It's voluntary, so we also need to understand how the industry will be pulled into and encouraged to do so going forward. But at this stage, I think the concerns are, from a legal perspective within organizations, they don't want to expose their organization by reporting matters, which could then be passed on to regulatory bodies, and there's potential consequence management through that.
So that goes to your earlier points, though, doesn't it? That there's a concern amongst your members. The Act, or the bill, I should say, protects them from any regulatory action that might be brought against them. But your members are saying, but where does the information go from there? Like, is it shared with other agencies where I might find myself getting in trouble?
That's right.
Is that right?
That's right, okay. Yes. So there's a piece of awareness and clarity is what needs to happen, in regards to that limited use obligation.
Mr Wallace, have you got any last-minute questions before we might need to start moving to the next witness?
Yes, I'll just finish up with this one, Chair, if I can.
That's all right.
Do you think the proposed limited use obligation hits the mark with these concerns, or do you have any outstanding concerns that have not been addressed in the legislation? I think you've answered that for me already, haven't you?
Yeah, yes, Mr. Wallace. I think there's further consultation and collaboration. I think that we will invite from the government on this particular point to better make the industry more aware and capable to understand where that line is drawn and what sort of information is required to be shared and any cascading effects from that sharing of that information.
Great. Mr Mittal, thank you so much for your really concise answers. It's enabled me to ask a lot of questions of you, and I really appreciate it. And thanks very much, Chair.
No problem. Thank you.
Thanks a lot, Deputy Chair, and thank you, Mr Mittal, for appearing today. Now, as I mentioned earlier, we've got a very tight time frame for this inquiry, but I know there were a couple of things that you took on notice, a couple of questions there from Mr Wallace, and maybe myself, but if you could please forward that to the Secretary by 4 p.m. tomorrow,
sure,
being November 1. Also my birthday, but anyway. You'll be sent a copy of the transcript of your evidence and we'll have an opportunity to request corrections to the transcript if there are any errors. On that note, thank you very much. Now we'll suspend very briefly and move to our next witness.
Thank you, Chair. Thank you, Committee.
Thanks, mate.
Thank you.
All right, welcome back, everyone. I now welcome a representative of the Cybersecurity Coalition to give evidence at this public hearing today. Good morning. For the Hansard record, could you please state your full name and the capacity in which you appear today? Are you there, Ari?
Hello.
Hello.
Can you hear me?
Yes. Can you hear me?
Excellent. Yes.
Okay, I'll start again. Good morning, and I'd like to now welcome the representative of the Cybersecurity Coalition to give evidence at this public hearing today. For the Hansard record, could you please state your full name and the capacity in which you appear today?
My name is Ari Schwartz, and I'm here today as the Executive Coordinator for the Cybersecurity Coalition.
And although the committee does not require you to give evidence under oath, I do advise that the hearing is a legal proceeding of the Australian Parliament and therefore has the same standing proceedings of its respective houses. Given false or misleading evidence is a serious matter and may be regarded as contempt of the Parliament of Australia. The evidence given today will be recorded on our Hansard and attracts parliamentary privilege within Australia but not internationally. Due to the very short time frame, the committee is also working within to complete its review. Could you please try and answer all questions or provide information to the best of your ability in evidence today, as further written answers will have to be provided within 24 hours if you do take any on notice. Now, Ari, have you got an opening statement that you'd like to make for the committee this morning? Okay, sure. And also, could you send us an electronic copy as soon as you could so I can circulate that to the committee members?
Yes, absolutely.
Fantastic. Fire away.
Chairman Ciccone? Yeah, should I go forward? Ready? Chairman Ciccone, members of the committee, thank you for this opportunity to appear before you today. My name is Ari Schwartz. As I've said, I'm the executive coordinator for the Cybersecurity Coalition. Our coalition represents a diverse group of leading companies dedicated to enhancing cybersecurity across all sectors. We are honored to contribute to this critical discussion of the cybersecurity legislative amendment package. While we are US-based, we advocate for best practice of cybersecurity policy globally. The bills are a significant step towards fortifying Australia's national cybersecurity posture. There's good reason for this package. Australia, like the United States and other like-minded nations, face two colossal collective action problems in cyberspace. One is the technical stack, which is insecure because security was not baked into its creation. The second interconnected issue is hostile nation states and criminal group actors dedicated to exploiting the weaknesses in the systems we rely upon as their full-time profession. This assessment will hardly be news to those of you who work in cybersecurity and national security. However, articulating a strategy which recognizes the relationship between these two can be difficult and complicated and complex. We recognize policy interventions like those included in this legislative package, particularly the Security of Critical Infrastructure Act reforms, are filled with trade-offs. So the Cybersecurity Coalition commends the Australian government for its proactive approach in seeking to address these challenges. In particular, the coalition supports the emphasis on providing the security of connected devices, utilizing a co-development process based on recognized international standards. We also support efforts to improve incident reporting. These elements are crucial for building resilient cybersecurity framework. I also want to commend the Australian government for its approach on industry consultation leading up to the delivery of the current Australian cybersecurity strategy, as well as the consultation process that underpins this legislative package. The Cybersecurity Coalition engages with a lot of governments globally on development of policy and legislation, and Australia is an exemplar in this regard. In discussions with other governments, we often reference the approach and consultation and co-design used by the Department of Home Affairs. Overall, the Cybersecurity Coalition considers the measures under the Cybersecurity Bill to be necessary and proportionate, but we have some suggestions on how they can be more effective. We understand the Australian government's rationale for these reforms to the Security of Critical Infrastructure Act. However, the reforms will add an additional layer of complexity and a compliance burden to the covered entities. These same entities have already spent considerable resources complying with the quick succession of recent Security of Critical Infrastructure reforms put in place over the last 2 years. With that in mind, we ask that the measures being introduced by the bill be implemented progressively with realistic timeframes that balance levying a reasonable burden on covered entities with the security goals of the legislation. We also suggest that consideration be given to more granular definitions around the key measures of the bill. For instance, with respect to Schedule 4, the Direction to Very Critical Infrastructure Risk Management Program, the definition of what constitutes a serious deficiency appears overly broad. To briefly summarize, the Cybersecurity Coalition is generally supportive of this legislative package, and we hope we can work with this committee and Home Affairs to ensure its long-term success. Thank you for the attention. I really look forward to your questions.
Thank you very much, Mr. Schwartz. And I just ask again if you could just agree to table that opening statement for the committee.
Absolutely.
Excellent. All right. Thank you so much. Now, I'll just ask a few questions before I hand the call over to the Deputy Chair. And thanks again for making time. I know it's probably late over in Washington, DC.
Yeah, it's about 8 o'clock.
But I'm sure a good time at the moment. Now, could you please talk for me through why you think it's appropriate for Australia to adopt the IoT standards that align with the top 3 provisions of the I think the European standards, the ETSI EN with that number 303645.
Let me take just a second. I don't want to go too far off base, but I think it's important for giving some context just generally of where we're going with the security of devices, of connected devices in general. So. Several years ago, the NIST, National Institute of Standards and Technology in the U.S., started a process to build together a set of standards. At the same time, you had the UK start to put together a series of standards as well. The two of them work together pretty closely in that regard. And we also had Singapore building a label for devices as well that reflected some of these same pieces. The UK standards ended up feeding into what became the ETSI standards that you're focused on today. At the same time, the US also took a lot of the NIST protocols and is built in the process of building its own label, similar to the Singapore label based on the NIST standards. So we have all of them sort of aligned, generally speaking, on this set of ETSI standards that are there, and we expect the EU to be using those standards as well. So we have that gives you the UK, US, Singapore, and EU generally focused around these same set of ETSI standards. So I think that in terms of a global effort, really Australia is coming in and also getting behind those standards really puts a pretty heavy weight on the rest of the world focused on those standards as well.
And I appreciate that. And I asked that question in the context that I understand the Department of Home Affairs here in Australia has I think already been consulting on such a standard being introduced once this legislative package passes our Parliament. Could I also ask then, why are you supportive of the tiered enforcement approach that's been proposed in the IoT standards in the Cybersecurity Bill?
I think in terms of the tiered standards, I think a lot of it really allows the ability to continue to have this through the co-design process, right? Build up an ability to strengthen security in different types of devices, because we're talking about a really broad swath of the economy eventually that is going to be covered by this. So having some sort of tiered piece to it helps to come up with a kind of better way of enforcing and figuring out what needs to be covered, and allowing that process of the code development to work through its course.
And what are the benefits? It does, thank you. So my next then follow-on question, what are the benefits of Australia having a ransomware reporting obligation?
Well, to me, there is a long process that we need to go through in order to get to the point where we are disincentivizing ransomware payments. And the very first step of that is reporting, right, where we have the vision into what's happening, and there's some sense that from those that are paying that people are going to find out about it, and it's not just going to be something that's kind of swept under the rug, so that they have to make more of a decision as to whether they're going to fight or they're going to pay. Because in a lot of cases today, it's just much easier to pay. That has changed over time, right? The ransomware groups we've seen now sometimes can't even give the keys to free things up, even if you do pay. So we have seen a lot fewer companies actually paying. And now we're starting to see a lot more kind of moves towards this kind of reporting efforts around the world. We see that as kind of the next step to how do we move down this path of nudging further and further fewer payments in this space. And Australia joining the group of countries that are already moving down that path is going to be very helpful in terms of narrowing those that see benefit in payment.
And just what you just mentioned with your experience, what happens then to instances where companies do pay, still have the issue of not that the ransom still hasn't been addressed? Are they then seeking further payments, or can you maybe elaborate what happens? Yeah,
there are some cases where people where the bad guys do seek further payments, or they do re-encrypt, and probably more so than there used to be, actually, more of those cases. But sometimes there is honor among thieves, and they do decrypt. So the question is, how do you disincentivize people from payment in the case where they see well, if I have to fight, it might take me months to clear this, to get my systems back online versus just paying where maybe I will or maybe I won't get it online, but it could be up pretty soon, especially if those payments are the fees, the ransom is not so high that it disincentivizes them from the payments. So I think that we've seen that change over time, where as fewer and fewer people pay, the ransom amounts have gotten higher, which sort of proves the general point. If we get fewer and fewer people to pay, then the decision becomes a little easier to say, oh no, I just want to fight, I want to be with the group that fights, as opposed to those that see the ease in payment.
Do you have that type of data, like showing companies that have been caught up in ransom?
Yeah,
how much the payment is?
There are a few groups that do the negotiations with the ransomware, with the ransom groups, and they have kept a general set of reports that they do on a quarterly basis. Two of them that we look at are Coveware and Kiva, are two companies that keep these kind of reporting. So you can actually see the data over time. It does go up and down, right? So when I say there's a general, I'm looking at the general trend of it going down, as opposed to, but because sometimes it does go back up. But in general, as compared to 2020 to today, fewer people are definitely paying than paid in 2020.
Oh, that's good. Now, with many submitters with this hearing and also in their submissions have made comment on what they believe to be an appropriate threshold for reporting obligations. What do you believe the threshold should be? And I don't know if you're able to elaborate a bit further from a US context as well too, but the need to have that threshold on reporting obligations.
So one of the things that we suggested is that you might want to have you might want to have a few tiers of where you have smaller companies that don't have to pay immediately, but over time you would add them into payment to having to report, if they pay. So to start with the larger companies, see how the process is working for you, see what Home Affairs is seeing, put out some of that data, then go and so that the smaller companies start to understand and know, eventually we're going to have to report as well. We should be preparing for this and try and stop it ourselves. But get the word out through starting with large companies and working to smaller companies in reporting. Because this whole process is really, as I said, it's all about narrowing the scope over time. It's not going to be something that happens overnight, and there might be some unintended consequences to it. But if you ease into it to some degree, you can narrow those secondary consequences by seeing what the reaction is. In the US, is there similar requirements? There has been. It is going into effect next year. It's called CyberCX. So, and that process is that, and that is. That any ransomware payment is going to have to be reported to the Department of Homeland Security. Is where they're going with that. So it's tied into the Critical Infrastructure Reporting Act as well. Whenever there's an incident in critical infrastructure, they have to report, and they also have a set of rules about ransomware as well. Yeah, but in terms of the package, I understand the government's also been consulting around, I think, a $3 million figure around as an appropriate threshold for their reporting obligations. What's the figure, or is there one in the US? It's still in draft form. I'd have to go see where the last draft ended up. I forgot what the exact number was from the draft. It's not in effect yet. So they're still taking it back. And we'll have to see what DHS and CISA end up coming up with as a final notice there. I can take that on notice and give you a number back. That would be great. Once I go look up over there right now. Yeah. And look, just finally, before I hand the call over to the Deputy Chair, you mentioned in your opening statement the importance of this package, and could you speak to just how behind you think Australia is with respect to its legislative framework for cybersecurity, and how important it is that we push and put this framework into place as soon as possible? Well, as we were just talking about, some of these areas are things that some countries, the US, the EU, UK, have started down the road of these efforts and have had a long process where we're getting to the point of having ransomware reporting right now. And talking about what that is and having draft regs already out there for it. So it's past the point of legislation, but it's the regs. Some of the items like the pieces on, I'm forgetting what I'm trying to remember what you guys call it. What we consider our Cyber Information Sharing Act, which gives liability protections for the companies that are sharing with the government. It's actually sharing with the government and sharing among themselves to encourage more sharing, voluntary sharing of information. That has been in place since 2015 in the United States, so we have a lot of experience with it. So that would be much further behind. So I think there's a range of like right on time to 10 years, somewhere 10 years behind. So, but I would say this. I mean, as I said in the discussion, I do think that you are a lot more open about your discussions, and you've cooperated very well with industry in building the pieces that you have, and I think that has also led you to getting a lot more information and cooperation from industry because of that. And so, in some ways, you are ahead of other places, and it's the type of thing that we hope that will catch on around the world. I also think that in some cases, some of the decisions you're making are ones where there will be, the ability to make where Australia can be the kind of kingmaker of, well, is the standard go in this direction or another direction, because Australia weighing in things are already moving in that direction. If you come in with with Home Affairs comes in using this act as its ability to authorize something that's similar to what other places are doing, but with a little bit more definition, you can really drive things in that direction. And the device standards is one example of that. Also, how you coordinate the board, the CIRB could be something like that as well. Coordinating with other governments could help to drive that in a good direction as well.
Thank you very much. And I think what you were trying to refer to, or you did refer to, but the word I think was the limited use provisions. I think is what we call it.
Use.
Yeah,
yes, thank you.
Yeah. That's all right. That's all right. Look, thank you very much.
Taking on the other side, right? So we're talking on information sharing versus limiting the use of the information once it's shared. So, yeah.
We got there in the end. That's the main thing. I'm now going to hand the call over to our Deputy Chair, Mr. Wallace. Mr. Wallace.
Thanks, Chair. Thanks, Mr. Schwartz, for your time today. And we realise it's getting late in DC, so we'll try and be as quick as we can. Just in relation to the Security of Critical Infrastructure and Other Legislation Amendment, Enhanced Response and Prevention Bill, in your view, do the new obligations proposed in this bill introduce a significant additional cost over and above the costs for compliance with the existing Security of Critical Infrastructure obligations?
In some ways, we'll have to see how it's implemented, right? Because it depends on, for example, how, as I was saying in my opening statement about their definition of serious deficiency here, right? That could be read very, very broadly, right? Anything that has impact to the Australian, to the government of Australia, to economic or individual harm, right? Those types of things can be read very, very, very broadly. If you're bringing a lot of those and forcing people, especially those that just built a cybersecurity risk program because they were required to a year ago or 2 years ago, right? That could bring with it a lot of extra costs, and where they're ramping up both their oversight and changing their protections all at the same time, and then reorganizing that as well. So you could talk about kind of consultants on top of consultants for some of these entities that are just getting up to speed, which worries us to some degree. We would prefer that it kind of be lengthened over time. Not that you don't end up doing it, but that you figure out how long it takes to bring that in, and also that you come up with a more defined, narrow scope for what a serious deficiency is.
By its very nature, the sort of businesses that will be caught up in the protection of security of critical infrastructure. We're not talking, and this is perhaps a loaded question, but we're not talking SMEs. We're not talking small to medium-sized enterprises, are we?
There can be, I think, for the most part, it tends to be less so. But there can be some smaller entities or entities with few employees, or right. It depends on the types of threats that you're seeing there and how that's defined in different sectors. So there can be some medical providers, for example, where it's a small group of people, but it provides a service that is life or death to some group of people, and therefore, or is the only place where something happens. What the estimate that I've heard is 1,500 to 1,600 entities in Australia. So to me, that it suggests that there are some that will not all be large. Right, and breaking it down by size could actually make some sense.
And so I'm not meaning to put words in your mouth. I'm merely trying to clarify your answers. It would be a mistake to have a rationale as legislators that it's critical infrastructure. It's going to be a major corporation. They can afford to deal with the consequences of this. That would be a mistake, wouldn't it?
I would not put it. I would be concerned if that was the attitude of legislators about it. Instead, I would say they do have obligations because they are critical infrastructure, but there are different varying sizes there which legislators should take into account and regulators should take into account as they're inputting regulations into place on cybersecurity here to make sure that it can work right for these smaller entities.
And as legislators, we like neat lines, for delineation. How do we as legislators delineate between some of these? Does this come back to your earlier comments about a risk-based approach?
I think we prefer a risk-based approach, and I can come back to you with a notice with some more details about how to break it up among the group. I think I have to have a little bit of a discussion with some of those. They know more about the specific Australia situation in some of the critical infrastructure sectors where there might be more smaller entities.
Okay. I think you know where I'm going on that. Obviously, we need to look after the smaller businesses and organisations, that we're not lumping a whole heap of obligations on them that just make their lives a misery.
Absolutely. I think if you saw from our February comments that we agree with that point for sure.
Okay, great. Thank you. Just in relation to the explanatory memorandum gives the example that the consequence management powers could be used to, and I quote, direct entities to upgrade their IT and OT systems to address any system vulnerabilities based on current threat information, close quote. What have you heard from government about how long this type of direction would or could last? Who'd bear the cost and who bears the risks?
Well, I think certainly the costs would seem to be bared by the entity, by the critical infrastructure entity, right? Which I think is part of the discussion that I was having earlier with the chair on how some of the concern about how this the effect could be tied into the period of time leading up to this point of the implementation of the original SOKI Act, right? And now you're putting extra effort onto them as well. But I think there's another piece of this, not to get too far off your original question, but I think that's really key here is when the government is giving information or giving directive to these companies for consequence under the consequence management powers, how much information is coming to the company that then has to implement, right? There's nothing in that we've seen in the Act, right, that says that government has to share the intelligence or share at least some kind of analysis to say, here is exactly what we're concerned about, and some sense of why. Obviously, there's some things that need to remain classified that you wouldn't tell, but there is at least some basic, if it's to the point where they feel that they need to take an action, that the company needs to take action, giving some sense of why and what action they expect them to take, so that they can build a conversation here to say, we're not going to, if we move to that has a whole bunch of secondary consequences and will break a whole bunch of other things in other systems. That's not your intent. If you give us enough information to actually address the problem, perhaps we can come up with another solution jointly that addresses the same thing, right? And so there has to be some kind of amount of information the government has to give, other than saying you have to switch off of this system and go to this system. That makes sense.
Mr. Schwartz, somewhat. Mr. Schwartz, I'm going to just ask you to try and keep your answers as tight as you possibly can, because we've got a bit of work to get through, and we won't get through it if. Okay, thank you. Have there been any discussions? Just going back to my first question, have there been any discussions with your organisation and government about how long a direction from government would or could last?
I haven't heard of any discussion about what that would be.
Okay.
No.
And the risks? Who bears the risks?
And I think that goes to some of the secondary consequences that I was just referring to. If you're giving if you're pushing for an action and telling someone to switch systems, that could obviously have secondary consequences, breaking other types of applications, breaking other types of other systems that are dependent on the one that you want to move. So there's a lot of potential risks depending on what the order suggests.
But the risks would be borne by the entity, though, wouldn't they?
Yes.
Yeah. Okay.
That's my understanding.
Yeah. What other legislation or policy frameworks, for example, at a state or territory level, would interact with the proposed consequence management power and should be considered prior to its use?
You have to take that one on notice to go in more detail now, yeah.
Okay, thank you. In relation to capturing systems which hold business critical data as critical infrastructure assets, what would be the financial and non-financial impacts of the proposed amendments?
You're certainly covering a lot more systems, right? I mean, you're not just getting at, you're getting at a lot of systems that hold personal information. There's which would cover a wider range of systems than are today. So you're covering a lot more systems. That I don't think there's an estimate out there for how many new systems would be covered under that. So but you can imagine that it would be quite a bit. And then you also have a problem of interaction with some of the other laws that are out there. For example, on the Privacy Act. And being able to deconflict those laws, et cetera, it bears some cost as well. So I think you're talking about quite a heavy burden on the companies. But then again, from what we have seen, it has been a major target for the actors out there. So it is important to cover it.
Mm-hmm. To what extent would the proposed obligations impact the ability to effectively use data for business purposes?
It depends on how far, what exactly the regs end up looking like in the end. And it depends again on some of this deconfliction, as I said, with the Privacy Act, but there could be some implication on the ability to use data. It is definitely a concern to be worried about.
Okay, thank you. The department issued 2 PSPF directives on 5th of July 2024, which relate to managing the risks of foreign interference in technology assets. Do you think these obligations should be extended to cover critical infrastructure entities?
I'll have to take that on notice to come back to that. I have a general sense of what my answer is going to be, but I want to make sure based on the actual text.
Yep. Okay. Well, I'll ask you to take these on notice unless you can answer these questions, associated questions with them. Do you think these obligations should be extended to cover critical infrastructure entities? Why? Why not? Would the current bills be a logical mechanism through which to mandate this?
I'll take that on notice, but
yep.
Yeah.
Great, thank you. Just bear with me 2 seconds. I don't think you've answered these questions with the chair, but if you have, please let me know. Can you elaborate on which international cybersecurity frameworks or standards you believe Australia is not aligned with, but should be aligned with?
Not aligned with, but should be aligned with. I think in general, Australia is moving in the direction of becoming aligned with most of those that I would name. I do want to go back and have a conversation. So let me take some of that. Let me take that question on notice. But I do think on some of the large ones, like we were talking about ETSI, the ETSI standards for IoT, we think that that's the right framework. There's a push on some of the ISO standards that also tie to the NIST cybersecurity framework, which I know that Australia has also taken on as kind of a voluntary effort, at least, to push forward. So those 2 being the big ones that I focus on, Australia is aligned with. But I want to make sure that I'm not missing anything to pass on as well. So I'll take on some, if we can put on notice a list of ones where they might not be aligned, that would be good.
That'd be great, thank you. What specific measures do you think could make a phased implementation plan workable? That is, how do you propose that we measure readiness or the threshold to move on to the next phase? Does that make sense?
Well, I do think starting in certain sectors that have been implementing based on the last round of SOKI, and looking at how it's being implemented. And then as you're moving in some of these new pieces there, picking up those sectors that have implemented well and seeing how they're implementing is probably one direct first kind of phase that you could have, and then going to those that have not been implementing well secondarily. So you're phasing based on sectoral implementation and those that have strength, right? I think the problem that we see is you don't want to end up with critical notices on top of critical notices. We see that too frequently, that the companies have trouble prioritizing if you start stacking critical control sets, critical failings on top of each other. So you want to try and get those ones that are succeeding and see how they're implementing, and then moving to those that are failing.
And does that go to your earlier point about starting with the larger companies and then bedding down those processes and then ironing out any problems or issues and then starting to work with the smaller ones? Is that what you were talking about?
I mean, it could mean that, but you also had these, risk management profiles that were sent in September, that were submitted in September, and it's more going through those and figuring out the ones that are successfully able to manage versus those that are not. So you could have small businesses that are successfully able to manage as well, but certainly size is a starting point as well. So in other words, I'm suggesting both size and the ability, the maturity. The maturity of the individual sectors.
Okay.
So because you're going to have some sectors that are more mature and have maturity models that have been used for many years, and they're able to come back in their September filing to be able to kind of give a very clear picture of where they are, whereas some sectors you're going to have that do not have maturity models are learning this, kind of pulling these risk management pieces together for the first time, and so if you're adding more pieces onto them, it's not going to kind of get you to success.
Right.
So focusing on where maturity is better. Size is often an indicator of that as well. So size and maturity at the same time can help to section that off to the ones where you're really going to get the most success versus the least.
Thanks, Mr. Schwartz. Thanks, Chair.
Thank you.
Thanks a lot, Deputy Chair, and thank you, Mr. Schwartz, for that. Thank you for making time again. I know you've got a very busy schedule and also line up your time with our time here in Australia. So thanks again for your attendance, and as I mentioned earlier, due to the very short time frame of the inquiry, if you could please provide, and there were a couple of questions that you've taken on notice, provide any answers to the Secretariat by 4 p.m. Canberra time tomorrow, being Friday the 1st of November. You'll also be sent a copy of the transcript of your evidence and have an opportunity to request any corrections should there be any errors. On that note, now we're going to suspend briefly for a break and return here in 15 minutes. So thank you, everyone. See you soon.
Thank you, Mr.
Thank you. All right, welcome back, everyone. I now welcome the representative from CyberCX to give evidence at this public hearing today. For the Hansard record, could you please state your full name and the capacity in which you appear before the committee?
Thank you, Chair. Full name is William Stoltz. I'm a Senior Manager at CyberCX.
Although the committee does not require you to give evidence under oath, I should advise you that the hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. Giving false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Due to the very short time frame the committee is working within to complete its review, could you please try and answer all questions or provide any information to the best of your ability in evidence today? As further written answers will have to be provided within 24 hours if you do take any questions on notice. Now, Dr. Stoltz, do you got an opening statement you'd like to make?
No, Chair, I think just to expedite the process today, it might be quickest if we go to questions, if that's all right with you.
That's fine, but you don't have an opening statement that you've already provided the Secretariat?
No, just the submission that we've lodged.
Okay, fantastic. All right, just wanted to clarify that. All right, excellent. Well, let's get straight into questions. Look, I've just got just a couple and then I'll hand over to the Deputy Chair. Can I just ask you, some of the questions I've been asking other witnesses today is, why do you think it's important for Australia to introduce security standards in respect of the IoT devices?
Well, I think it's a rational response to an increasing threat environment. We've seen a number of high-profile instances targeting consumer devices, networked infrastructure, and this is a very prudent measure and very much in line with the government cybersecurity strategy to focus on trying to secure individual users and businesses in the first instance. And this should be quite a practical and hopefully world-leading initiative to really strengthen the resilience of our ecosystem of technology.
And are you supportive then of the proposed approach from the Department of Home Affairs that the initial lot security standard would match requirements imposed on IoT devices in the European Union?
Yes, we're supportive. And just make the observation in our submission that it is nevertheless an opportunity to potentially evaluate whether Australia can undertake the creation of its own improved standards. It's just a general observation to say that while, of course, the European Union standards and the standards that exist in the United States are very, very good, whether it's not an opportunity to potentially evaluate in a general way whether there are aspects of Australia's relationship with technology that would warrant potential introduction of our own kind of bespoke standards. But that's just a general observation.
Your submission also talks about the importance of having an incremental approach to the implementation of these standards, starting with consumer goods and then expanding to, I guess, incorporate equipment in industrial supply chains. Why do you think this incremental approach is important? And shouldn't we just proceed to protect equipment in the industrial supply chain with just as much speed as we would with, I guess, other consumer goods?
Well, I suppose it's just a practical recognition of the complexity that will be involved with introducing the IoT standards to that more complex operational technology in an industrial context. Certainly, we accept that it's an urgent task and should be implemented as soon as practical, but it just may be the case that if this measure is to align with the government's cybersecurity strategy of first and foremost securing as many Australians and entities as quickly as possible, it's logical that if you were to take a phased approach, that you would start with retail consumer electronics and then build up to that more complex ecosystem of technology around industry.
And I also note in your submission, you, I think, make the case, or at least point to the fact that you don't support the establishment of the Cyber Incident Review Board. Why is that?
No, that's right. Our view is essentially that to put it candidly, the Cyber Incident Review Board is some extent a solution in search of a problem. We believe that there are already a number of mechanisms available to the government in order to undertake the sort of no-fault independent review of incidents. That could include leveraging the analysis and assessments that's already prepared by the Australian Signals Directorate and the Australian Cybersecurity Centre. That could potentially include leveraging the ability of Cabinet and ministers and the Prime Minister to appoint independent reviewers or even Parliament's capacity to undertake inquiries and potentially even the ability of departments and agencies to commission independent research from external organisations. Our view is essentially that this is the use case for this is not being as well established as potentially it needs to be.
So you suggest that maybe this committee needs some more oversight or have the ability to have oversight on such matters?
Well, I suppose it's maybe not necessarily a question of oversight, but it's more a question of effectiveness. If we're going to continue to expand the ecosystem of institutions that are around the operations of protecting Australia's cybersecurity, that each additional institution be added with a really clear purpose. And in this instance, our view is that there is not a clear purpose and that there is, if anything, something of a confused purpose. On the one hand, the proposal would indicate that the focus of this board would be to create independent, no-fault post-incident reviews that can kind of generate high-level lessons learned to improve future incident response. But on the other hand, the explanatory memorandum does lean heavily on the United States Cyber Safety Review Board as a kind of model. But the observation we would make is that that board is probably more of a joint operational board. It does give the remit to the public officials who are on that board to leverage the insights gathered through the incident reviews to inform their own law enforcement and intelligence collection activities. And I guess it's just about emphasising to say, well, is this board's purpose to create independent analysis and no-fault reviews, or is it to support investigations that might be otherwise done by other agencies?
I'll just ask this question and then I might hand over to the Deputy Chair, but why are you supportive of the amendments to the Saki Act to protect data storage and business-critical data?
Well, I think it's a rational approach to acknowledging that what's important here is the data itself, not necessarily the physical infrastructure in which it's stored. And therefore, the focus of the legislation should be about saying what data is so fundamental to the operation of these critical services as opposed to the infrastructure. And the application, therefore, of capturing third parties that might be essential to providing data services to critical infrastructure and systems of national significance entities is a prudent one.
Okay. Look, I'll just leave it there. I'm mindful of our time today, but I'll hand over the call now to the Deputy Chair and they might come back with some other questions. But Mr Wallace, you've got the call.
Thanks, Chair. Thanks very much, Mr Stoltz. You recommend that the government rely on existing agencies like ASD and ACSC as opposed to introducing a new cyber incident review board. Do you think that ASD and ACSC have the capacity to do that, given their really increasing workload?
Well, I suppose this is the important distinction: is that this is probably a legislative solution to a capability problem, in the sense that the powers are already there for ASD, the Cybersecurity Centre, and potentially another number of other entities to undertake independent reviews or reviews that are getting towards what's been proposed. But as you say, it may be the case that the resourcing available for those entities to perform that function might not be there.
Does it fit? I mean, just sort of exploring that a bit more. I wonder whether the review board's role and I take your point earlier that you made with the chair that you think that there's a bit of a confused purpose, but I'm just not sure that it would fit neatly, particularly within ASD's role.
Potentially not, but it depends on the purpose. If the focus is to have truly independent reviews that are at arm's length and no fault on a no fault basis, then, for example, why not use a grant program to commission a university or a group of researchers to undertake a review? Why do we need to legislate this function?
Okay, so your concern is more around do we really need to legislate this as opposed to do we need the body?
I think that's right. It's just about scrutinising whether this is a problem that's best solved through legislation and indeed the extent to which the problem really exists. Because if it is the case of simply leveraging existing mechanisms and redirecting existing resources to get that higher level insight of how an incident has been responded to, then that's simply up to existing officials to direct their agencies accordingly.
You spoke earlier with the chair about the US equivalent, and are you able to advise the committee on the makeup? You may have heard Mr. Mittal from the Australian Information Security Association talk earlier about in his evidence that he felt that it should be sat on by not just APS workers but by academia and industry.
So my understanding of the US body, the Cyber Safety Review Board, is I believe it has 8, I can't remember the specific agencies, but it's 8 agencies represented on that board. Law enforcement and intelligence agencies, as well as experts from external to government. Is your question about which Australian officials should be represented on the Australian version?
Sorry, I didn't ask my question very well. I apologise. I conflated 2 questions in one. One question was going to be, the comparison between the US model and who sits in the US model, and the other issue was, do you think that the way that we've currently looked to introduce the CIRB, whether we need to look beyond the APS seats on that board?
Right. Yes. I think if you were to proceed with this model, then it would be prudent to be able to draw from a pool of experts as been suggested by the department through the legislation, so that you have a pool of experts that you can build a kind of bespoke team for reviewing each incident. Because obviously, depending on the industry, depending on the nature of the attack or breach, you will need a selection of different experts brought to bear to undertake that incident review. In terms of the transferability of the American approach, I would just emphasise a point that we make in our submission, which is if this is to proceed, it should be clarified how agencies' existing investigative powers, whether they be law enforcement or intelligence investigations, are meant to interact with the investigations undertaken by the board. Is it the case that those officials who are on the board have to air gap that participation in the review from the use of their agency's investigative powers? Or is it the case that what they're able to collect through the review process is able to inform law enforcement or intelligence investigations?
But there are the limited use provisions, though. Wouldn't that do the job?
I think you might be potentially conflating that with the limited use powers. I don't remember specifically there being limited use articulated in the description of the incident review board, but I'm happy to take that on notice and have a look.
So my understanding is that, and I might be wrong on this, but my understanding was that information shared with the review board couldn't be used against the company for a regulatory penalties, etc.
For regulatory penalties, that's right, but whether that presumably wouldn't affect investigations undertaken by law enforcement or intelligence agency. And I suppose the point that we've made in the submission is just to say, and I think the instances in which this would arise would be infinitesimally small, but just to clarify that you would not want officials on the review board to be using the review board as a way to undertake investigations that should otherwise be undertaken with the use of a warrant for intelligence or law enforcement collection.
Yeah, I think that is a very well made point. Thank you. Did you need to take anything on notice on that issue?
And if you're satisfied with the answer I provided, otherwise I can take something on notice.
Well, I'm satisfied, provided you're satisfied that you've given a full answer.
Very good. Satisfaction all round then. Very good.
Okay, good. No worries. Now, you propose aligning the ransomware reporting threshold with the Privacy Act's $3 million limit. I'm interested to know, why do you think this threshold is fitting for these new reporting obligations?
I don't recall that we specifically emphasised. I suppose the point is, if a threshold is to be found, then that is a logical place to start. I note the submissions by a number of other organisations, Council of Small Business, and I believe a number of others, suggesting that the $3 million threshold is potentially too low, that it will capture organisations that are quite small, businesses that are quite small, and that they may struggle to deal with the reporting obligation. I suppose we're not unsympathetic to that argument, but would just make the point, I suppose, that if the government's intent, as articulated in the cybersecurity strategy, is for the ransomware reporting regime to capture as wide a cross-section of the Australian community as possible in order to garner the most richest insights of the ransomware threat as possible, that it does make sense to capture small businesses. If other institutions believe that that is going to have a very significant impost on those smaller entities, the committee may wish to consider potentially a phased approach where you start the introduction of the ransomware reporting regime for those higher entities that can accept the obligation. And then once the performance of the program is established, then you expand it, because I think what's at the core of the value proposition of the ransomware reporting regime is the suggestion that in response to providing these insights on ransomware incidents, the business community will gain access to aggregated insights around the ransomware threat that are going to be useful for them to protect themselves. So I suppose what the committee may wish to really satisfy itself of is that those insights are going to be readily available. Because if an impost is put on business that in a 72-hour period after incidents happened, you have to report all this information, there should be a kind of quid pro quo, so to speak, of being able to have ready access to the insights that are established as a result of the reporting regime.
Okay, and that seems to me to be a bit of a common theme coming through, that there is a concern around the lack of feedback that comes back to businesses. Is that a fair enough observation?
Yes, I think that's our concern as well, that we would want to make sure that entities that are undertaking this reporting have got a really user-friendly, accessible experience when it comes to both undertaking the reporting, but also being able to get access to insights that are genuinely useful for them in their business operations. Okay,
thank you. I know I'm bouncing around a little bit here, but I want to take you back to the review board. Do you have any concerns regarding information sharing with the review board, particularly around confidential or sensitive commercial data?
Well, I suppose not specifically. We did raise the question in relation to the limited use obligations, and I suppose it applies here as well, that we would want to make sure that where organisations are voluntarily forward-leaning and proactive in assisting the government, whether it be through reporting through limited use obligations or through the incident review board process, that they aren't inadvertently adversely affected. Say, for example, if you're a data center business and you decide that you're going to be very proactive and a good corporate citizen and report as much as you can voluntarily to the government, that reporting doesn't potentially adversely affect you in, say, a commercial relationship with the Commonwealth, that those insights aren't shared widely inside government, that suddenly, because you've given all this rich insight about your organisation, that you are now having adverse effects on you, even though you did the right thing.
So how do we ring fence that legislatively?
Well, something we've suggested is the potential to follow the approach that's undertaken in, say, the electronic surveillance powers, which is you have a general prohibition on sharing and disclosure with very specific exemptions called out in the legislation, so that it's very clear within government and to the community what this information will be shared and used for, with the idea being that if it's not specified, the assumption is you can't share it.
Mm-hmm. What sort of exemptions would you envisage would be reasonable?
Well, I suppose, obviously, like law enforcement and intelligence operations would make sense. Anything relating to national security, the protection of people in life-threatening situations, those sorts of things. But certainly, what we wouldn't want to see is information that's been voluntarily shared being, say, distributed to other organisations within government to inform a commercial decision, to inform a tender process or something like that.
Yeah. Okay, good. Thank you. Just finally, the explanatory memorandum notes the standing members of the board, as it currently is envisaged, will be members of the public service appointed by the minister. Do you have a view on whether the board's standing membership should be restricted to APS? You've kind of answered that. Or actually, that wasn't the question I wanted to ask you. The other question I want to ask you is, do you think the provision for the minister to approve the terms of reference for any review conducted by the board will undermine the board's independence? Do you need me to ask you that again?
Well, I suppose I'd just make the general observation that if the intent is to create the most independent possible process, being able to take the widest possible remit in terms of what the board is able to review, then you would probably want to remove that from the minister's discretion, so that the board is able, particularly in the process of undertaking a review, able to kind of continue to expand, if it needs to, the remit of what it's examining, because there is that, I suppose, the trick of you don't know what you don't know. And if you've started with a particularly tight remit in the terms of reference. Now, of course, I would imagine logically there would be an option to go back to the minister and say, we need to expand the terms of reference. But it could, conceivably, it could impact the perception of the independence of the reviews.
Great, thank you. That's all I have for this witness, Chair. I'm not sure if Ms McKenzie has any questions.
Well, I'll ask that. Ms McKenzie or Mr. Gosling, if you don't, that's okay. We can let the witness go. Gone. All right, well, on that note, thank you very much.
Hello, friends. I'm good at my end, sorry.
Oh, okay. Ooh. That's all right. I think the internet was a bit sketchy. Was that a no? I think that was a no.
That was a no.
Yeah.
That was a no, Chair. Yeah.
Okay. Well, thank you very much for your attendance. And again, due to the very short time frame of the inquiry, as I mentioned, if you could please... Where did the witness go?
I'm still here.
Oh, there he is. Sorry, I'm just trying to look at... it's too many screens flicking around. It's reminded me of COVID. But anyway, you have till 4 p.m. Canberra time tomorrow to provide the Secretariat with any answers with respect to questions that were taken on notice. And we'll also send you a copy of the transcript of your evidence and have an opportunity for you to request any corrections should there be any errors. On that note, thank you very much for appearing. We'll suspend very briefly Chair, and get ready for our next witness. Thank you. Let's go. All right. Turn over the page. Now, good afternoon again. Now, we'll welcome representative of the AISA Software Alliance to give evidence at this hearing today. And for the Hansard record, could I please ask that you state your full name and the capacity in which you appear before today's committee hearing?
My name is Tam Shen Hong, and I appear on behalf of BSA, the Software Alliance.
Thank you for that, Tam. Now, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Australian Parliament and therefore has the same standing as proceedings of the respective houses. Giving false or misleading evidence is a serious matter and may be regarded as contempt of the Parliament of Australia. Given the evidence today will be recorded by Hansard and attracts parliamentary privilege within Australia, it does not internationally. Also, due to the very short time frame that the committee has to report back to the Parliament, could you please try and answer all questions or provide information to the best of your ability in evidence today, as further written answers will need to be provided within 24 hours, should you take any on notice. Now, do you have an opening statement for the committee this morning or this afternoon, Tam?
I do.
Okay, and could you also please circulate a copy for us and we'll have that tabled?
Certainly, Chair.
Thank you. All right, proceed.
Thank you, Chair. Good afternoon, honourable members of the committee. BSA, the Software Alliance, appreciates the opportunity to participate in this important inquiry. BSA is an industry association headquartered in Washington, D.C., with offices in Asia, Europe, and Latin America. We represent the global enterprise software industry. Our members develop solutions that power other businesses. Many of them, such as Atlassian, Adobe, Cisco, IBM, Microsoft, Salesforce, SAP, and Workday, have made significant investments in Australia. Cybersecurity is a key policy area for BSA and our members. A secure digital ecosystem is fundamental to tech-driven growth and innovation. As cyber threats continue to evolve, so too must our regulations and policies. There is increasing recognition that cybersecurity is a team sport, and public-private coordination is more important than ever. In this regard, BSA supports the majority of the proposed reforms in the cybersecurity legislative package. Many of them emphasize communication and cooperation across public and private sectors. Notable ones that BSA supports include the following. First, the limited use obligation for information provided to the National Cybersecurity Coordinator and the Australia Signals Directorate. Second, the ransomware reporting requirement, which is undergirded by no fault and no liability principles. And third, the creation of a cyber incident review board, which includes an expert panel that will be staffed by industry professionals with high levels of expertise. In our view, these proposed reforms provide much needed certainty to businesses on how cyber incidents will be managed by the relevant authorities. It also avoids perpetrating a culture of blame when cyber incidents occur. However, we remain concerned about two key matters. First, when entities provide authorities with sensitive information on a cyber incident, the authorities are not required to seek the entity's consent before sharing the information, nor explain why such information needs to be shared and with whom it will be shared. This is concerning because most of the information shared by the entity will be sensitive in nature, and the entity will have no way of knowing how this information is being used and which agencies it will be shared with. Providing industry with more visibility into how their information is being handled is crucial, as this will engender greater trust between the industry and the government, ultimately encouraging more reporting. In this context, we recommended that authorities seek consent from the entity to share information, and in the process explain why the information has to be shared and with which specific agencies. Second, there are still no independent oversight mechanisms over the government-assisted powers in Part 3A of the Security of Critical Infrastructure Act, powers which will be expanded by the proposed reforms. While the SOCI Act, for short, provides safeguards, they only require the relevant minister to consult within the government and the affected entity before the power is exercised. As such, there is no independent check on these broad powers to deter potential misuse. There are also no avenues for the affected entity to appeal the exercise of these powers. As a general matter, policies that introduce broad intrusive powers, even for the purposes of upholding national security, can compromise user confidence in the affected entity's products and services. These powers should therefore be subject to rigorous checks and balances. Notwithstanding these concerns, BSA would like to reiterate our general support for the legislative package, which reflects the importance of public-private trust and partnership. This should always be the cornerstone of cybersecurity. With that, I thank the committee for inviting BSA to this hearing and look forward to any questions you might have.
Thanks a lot for that. Look, just a few questions and then I'll hand over to the Deputy Chair. Noting your support, I think, for the package overall, I just wanted to ask you about the reporting, the compulsory reporting regime from ransomware payments and also the turnover threshold. There's been some discussion today, not specifically in the bill around the $3 million figure. I think that's a figure that's been consulted by government and will probably follow once the legislation has been passed the Parliament, should that occur. But I just wanted to ask you about the figure. Is that a figure that you believe is right, the $3 million? And if so, we've heard other evidence, but I'm not sure if you've got something to add to the commentary from this morning.
Well, thank you very much, Chair. BSA does support setting a $3 million Australian dollars threshold for entities to report ransomware incidents. There are two reasons that I will point to, some of which might have been uttered before. The first is that this $3 million threshold will increase the sample size for ransomware data collection, which is of course important for threat identification, so on and so forth. The second reason is it will promote robust cybersecurity practices across all enterprises. It highlights that cybersecurity is not just a quote-unquote big tech issue, but one that affects enterprises of all sizes.
Yeah.
Yeah.
Sorry, keep going. Sorry, that was me coughing.
Right.
Sorry.
Oh, no worries. Yeah. I suppose one supplementary thing I'll add is that it also aligns with the small business definition under the Privacy Act. This does promote greater harmonization among different laws, which we strongly support as well.
I do note you disagree with the direction given powers, including the SOTCHI amendment, but these changes don't really impose any new, obligations, do they? I'm just wondering if you could expand about why you disagree.
I think our fundamental disagreement with it is that there is a lack of independent oversight mechanism. Chair, you are right in observing that it doesn't impose a new sort of obligation. In fact, one of our concerns previously was that they would legislate an entirely new power or hazards power of last resort. This did not come to pass. Instead, they've just amended the existing government assistance powers so that it applies to not just cyber incidents. So the key difference there is that it clarifies the scope of the existing powers. Of course, going back to my opening statement, our concern in respect of the consequence management powers really lie in the lack of an independent oversight mechanism, which I can elaborate on if Chair, you'd like me to.
Sure, that's fine.
So, in respect of this concern that we have, this has been an issue we have consistently flagged actually since the SOKI Act was last amended to introduce the Part 3A powers. As I recall, in the PJCIS's advisory report on the amendments in September 2021, some members of the PJCIS then flagged concerns about, I quote, the absence of independent authorization and the wholesale exclusion of statutory judicial review in relation to the measures in Part 3A. These are the same concerns that we are raising today, Chair. From industry's perspective, policies that introduce intrusive powers can certainly compromise user confidence in the integrity, the trustworthiness of the service providers, products and services. And we think it's very important that these powers be subject to appropriate checks and balances.
I asked that question in the context that it would allow the government of the day to direct entities already in the scope of SOTCHI to uplift their compliance without the government having to undertake court action to achieve that. So it's, I guess, a power that probably already exists, but there's a different process or manner in how we would exercise that existing power.
Chair, it might clarify, you are referring to this review and remedy power that was that they are looking to introduce into the SOKI Act. Would that be correct?
The amendment in the SOTCHI Act.
Right.
Yep.
Yes.
Yep.
Yes. So our view on that is that it is perhaps a little premature to introduce this power. As I understand, it was only in August this year that all the cybersecurity obligations in the critical infrastructure risk management program rules are active. The critical infrastructure entities would have only just submitted their first board-approved annual report last month. So from our perspective, really, there's no clear evidence that the government requires such a power. I recall reading in the Home Affairs Impact Assessment that they have done trial audits, and these trial audits, the results of these trial audits have shown that the risk management programs of various entities are not up to par, but no further details were provided. So again, going back to my earlier point, there's no clear evidence currently that the government requires such a power.
Now, do you believe the limited use provisions in the bill are satisfactory?
Generally, yes, Chair. We believe that the limited use provisions in the bill are satisfactory. We support, the limited use obligation.
Yeah, because I know in your submission I think you suggest implementing consent arrangements on sharing.
Yes.
Okay.
Yes, you are right. So the limited use, the limited use part of the information sharing, we certainly support. Just to clarify, as you are familiar, the obligation ensures that government agencies can only use the information for permitted cybersecurity purposes. So this, in our view, is a good safeguard. We also note that the bill states that the impacted entities may voluntarily provide information to the coordinator or to ASD in relation to major cybersecurity incidents. So that voluntary nature is something that we support as well. Of course, Chair, you pointed to our concern in respect of how information will be used. At the end of the day, it does go back to transparency. Most of the information shared by the entity will be sensitive in nature. And as I mentioned in my opening statement, the entity typically has no way of knowing currently how this information is being used, which agencies it will be shared with. So that's where our concern is like.
So just for clarity, so I understand what you're suggesting would be that every time a government agency shares information provided under the limited use, do you think that's a practical outcome here, that they need to go through a process seeking consent every single time, rather than maybe having a framework where it might be reported? But I'm just concerned, and I guess the context for my question is the concern might be that does it slow down a process when we need to act quickly?
Thank you very much for that question, Chair. It is a great question, and we certainly recognize that time is of essence in cybersecurity incidents. I suppose one of the most important things when such incidents occur is communication, and there are ways to facilitate communication that can expedite such consent-seeking processes. For example, entities could agree beforehand to information sharing protocols in advance so that when incidents occur, information is given, consent is given sort of by default. But this, of course, is subject to agreement with the various parties. Also, one point that I would raise is that when incidents occur, companies, businesses can, and in some markets are in fact obliged to provide a quick verbal notification to the relevant agency. So from our perspective, it's certainly worth considering whether or not agencies can do the same in a quid pro quo. I suppose, at the very least, again, recognizing that time is of essence in such incidents, the impacted entity should at least be informed about what information was shared and with whom. Ultimately, it just goes back to communication, transparency, and trust. And if you talk about the ultimate policy objective of encouraging more reporting, we think that this is something that's definitely worth considering flagging.
Okay. But you do acknowledge some of the risks with that, in that it might slow down the process by having to seek permission every time you go through the various stages, rather than maybe having a framework alongside where it's reported, rather than seeking permission every single time.
Chair, yes, we do acknowledge that there will be certainly some slowdown in the process.
Yeah, okay. Now, just check to see if the Deputy Chair is online. It looks like he is. Deputy Chair, you have the call.
Thanks, Chair. Thanks very much. Mr. Hong Tam, is it?
You can call me Tam or Shen, both are fine.
Mr. Shen?
Yep.
Thank you. I've got a series of questions I'd like to sort of rapid fire ask you, so I'm going to ask you to try and, as best you can, keep your answers to be brief, if that's okay.
I'll do my best.
Thanks very much. Just in relation to the ransomware reporting, given the obligation only applies when ransom payments are made, not when they are demanded, do you think there needs to be a floor on annual turnover?
That's a very good question, Deputy Chair. We do not think that there needs to be a floor on annual turnover.
Okay. Do you want to say why?
Elaborate. Okay. So I think
just after telling you to keep your answer short.
right. Absolutely. So I think returning to first principles, right? When it comes to instant reporting, we want to ensure that reports are focused only on the most significant incidents. So you avoid the noise that can come from an overly broad reporting obligation. So as you noted earlier, reporting only after the payment is made would be, in our view, sufficient to limit the reporting to only situations where it is most crucial to report. That combined with the 3 million threshold, we feel basically would make the ransomware reporting obligation fairly effective.
Okay, thanks. Once a payment is made, the ability of government to assist in any meaningful way is likely past. Do you think the reporting obligation should apply before a payment is made, e.g. when the ransomware attack originally occurs, or a declaration of an intent to pay prior to payment occurring?
No, we would very much prefer that reporting obligation only be triggered after the payment is made and not upon receiving a ransomware demand. As mentioned earlier, this ensures that reports only focus on the most significant instance, but also you avoid having basically confusion and uncertainty over what exactly constitutes a demand that causes significant impact on a business. If I receive an extortion email without any further elaboration, does that constitute a demand that is worth reporting? I'm not sure.
Okay. This is a very subjective question, but I'll ask it anyway. Under what circumstances, if any, would you contemplate making a ransomware payment?
That is a very difficult question to answer, Chair. I'm not privy to the considerations in which either my organization or our members would make a ransomware payment. I think it really varies depending on the circumstances. Yeah. I'm sorry, that's not, I suppose, not very helpful, but yeah.
Okay. Do you think there's a risk that instituting a mandatory reporting regime could be perceived to legitimise the paying of ransoms as an appropriate response to a cyber incident?
I do not think so. I see no reason why it would encourage, why having a reporting obligation would encourage businesses to make ransomware payments. I think there has to be another limb to this discussion, which is education and uplifting cybersecurity, just the cybersecurity capabilities of all enterprises when it comes to ransomware payment.
No, it's more around the legitimisation of the ransomware by having a reporting procedure.
I'm not sure I fully understand that feature, so maybe you could just repeat your question again. So,
do you think there's a risk that instituting a mandatory reporting regime could be perceived to legitimise the paying of ransoms as an appropriate response to a cyber incident?
Well, my answer is still no, Deputy Chair. I do not think that it will legitimise it.
Yeah, no, that's okay. Just on the minimum standards of IoT devices.
Sure.
Just bear with me 1 second.
Of course.
Actually, I'll come back to the ransomware again. Could and you may have, I don't know if you've been listening to other witnesses give their evidence so far this morning, but could the $3 million annual turnover threshold for reporting incentivise malicious actors to target small businesses in the knowledge that the attack will likely go unreported?
So, Deputy Chair, I think that small businesses are already being targeted because they are probably the most vulnerable sort of enterprises in the sector. They do not have the same resources, expertise that some of their larger counterparts have. So I do not think that having the reporting obligation would encourage, I suppose, malicious actors to specifically target small businesses. I think in fact, having this reporting obligation will provide more information as to where these threat actors are coming from, the threat patterns, so on and so forth, which I think is extremely valuable. And again, going back to the policy objective of the government, I think this is entirely in line with what they want to achieve from these reforms.
Okay. Thank you. Return to the minimum standards for IoT devices. How prepared do you think industry is to implement mandatory security standards for IoT devices should the bill be passed?
One thing that I would note is that implementing a mandatory standard does go beyond voluntary measures and labeling schemes that are considered by other like-minded countries, such as Singapore and the US. Based on my understanding of our members' capabilities and resources, I think they have implemented or are prepared to implement, some level of minimum baseline security standards. I think our issue is that these must be pegged to some sort of international standard, right, to ensure interoperability and compatibility and to minimize regulatory burdens. So one thing that we would really discourage is taking a sort of divergent approach from other like-minded countries, like coming out with a domestic, an Australian-only standard, for example. One thing that would really help is recognizing and accepting internationally recognized standards. So as I recall from the consultation, they were referring to the ETSI EN 303 standard, which was great. It is an international standard. It's recognized by NIST, Singapore, so on and so forth. But there are others as well. The International Standards Organization 2742 standard is something that we have pushed for in our submission. And that's certainly something that, as they put together this set of security standards for Internet of Things, we urge interoperability to always be front of mind.
In the event that manufacturers of low-cost devices opt to exit the Australian market due to the additional compliance burden, is there a risk Australian consumers will opt to buy the same devices from intermediaries overseas without the protections that would apply in Australia?
So, based on what I have observed in the course of our advocacy, the security, the legitimacy of these products and services is becoming more and more of a consideration when I suppose consumers purchase these devices. So in our view, in our view, the effect that of the situation that you have painted out for us, I think that might not be as pronounced as some of us might think.
Okay, so you think that Australians are or would be more willing to pay the extra and ensure that they get the appropriate security mechanisms than adopt a cheaper approach and buy something overseas?
Yes, I think assurance. Again, this very much depends on the facts and the circumstances, but from my understanding and my observation, I think security is a big part in terms of the cost-benefit analysis, shall we say, when any business, in fact, chooses to buy a certain product or service.
Mm-hmm. Okay, thank you. Just in relation to the limited use obligation, I think you may have covered some of this with the chair, but The explanatory memorandum states, and I'll quote, information provided to the National Cybersecurity Coordinator under the obligation with respect to the entity's actions relating to the cybersecurity incident is not admissible in regulatory proceedings against the entity to the extent possible. Are there any circumstances that you are concerned about where information provided under the limited use obligation could be used in legal proceedings?
Based on our consultation with members, this scenario has not arisen. We appear generally comfortable with the safeguards that are in place when it comes to the limited use obligation. As mentioned earlier, the sharing is voluntary and it's limited to permitted cybersecurity users. So on the face of it, we think that the probability of it forming the basis of any sort of legal proceedings is highly unlikely. Section 42 of the Cybersecurity Bill also quite clearly sets out that information is not admissible as evidence in criminal and civil proceedings. So we are quite comfortable where things have landed in this regard.
I'd have to check the relevant provision, but does that extend to other civil proceedings, or is it only in relation to criminal or regulatory proceedings?
If you would just give me a moment to check.
No.
Right from me.
And I might get you to give me the section number if you wouldn't mind.
Sure, it's section 42 of the Cybersecurity Bill, 42 subsection 2, subsection A, B, C. Yeah, civil proceedings for contravention of the civil penalty provision of a Commonwealth, state, or territory law. That's the one that I was referring to.
So would you mind reading that again?
Section 42, subsection 2, subsection B, admissibility of information voluntary given by impacted entity. The information is not admissible in evidence against the impacted entity in any of the following proceedings. Civil proceedings for a contravention of a civil penalty provision of a Commonwealth, state, or territory law, other than a civil penalty provision of this part.
So I read that to mean that if it's civil proceedings where there is not a civil penalty, then that could be used. So that the information, the evidence garnered as a result of this disclosure could be used in civil proceedings, but it couldn't be used in proceedings where there was a civil penalty. There's a distinction between those two issues.
That's a very good point, Deputy Chair. I must admit that I did not consider that interpretation. That being said, I think there can certainly be more clarity as to how this provision would apply in practice.
Do you want to take that question on notice, just with that little bit of additional thought?
Sure, I'll take that question on notice. Thank you, Deputy Chair.
Thank you. Thanks. One of the do you have any concerns about circumstances in which information was provided under the limited use obligation? Look, I'll leave that. Sorry, I'll leave that question because I think you're going to deal with that in your taking that on further notice. So I'm going to refer you now to the Cyber Incident Review Board.
Sure.
Do you think the provision for the Minister to approve the terms of reference for any review conducted by the Board will undermine the Board's independence?
That's a very good question. We do not think that it will undermine the Board's independence insofar as there are a variety of, I would say, both public and private professionals that will be part of the Board. And I think that in regard, I think that is sufficient.
So my understanding, and I'm happy to be proven wrong on this, Mr. Shen, but my understanding is that the current makeup of the board is that it will be sat upon by public servants only, and there is a concern that if the board is sat on by public servants, as opposed to what is the case in the US, where it's sat on by subject-specific experts, academics, industry, and public servants. But if the minister can call the shots on the terms of reference, you never announce an inquiry where you don't know what the outcome is, right? That could undermine, at the very least, the perception of independence of the board. I'm not putting words in your mouth. I'm putting something to you, and I'm inviting a response.
Thank you very much for that, Deputy Chair. Noting again what you mentioned, it is of course extremely important to ensure that the perception of the Cyber Incident Review Board, that the Cyber Incident Review Board is seen to be objective, and I think. I will concede that it does give a certain perception of, I wouldn't say a lack of independence, but certainly the fact that it is that the board itself is staffed entirely by the public sector could feed into that perception. That being said, the expert panel, in our view, incorporates enough of the private sector that it can help to mitigate, I think, this perception.
Okay, thank you. Do you have any concerns regarding information sharing with the review board, particularly around confidential or sensitive commercial data?
We do. We typically we have flagged concerns regarding giving the Cyber Incident Review Board powers to compel entities to provide information. In our thinking, there may be circumstances where a company representative, for example, is part of a panel that's tasked with reviewing an incident involving a competitor. So the ability to require the competitor to disclose sensitive information, we feel does not reflect well on the board's objectivity and impartiality.
But that would only be the case if there were industry people sitting on the board, though. Have I got that right? If the information was being shared with the board in its current makeup or current suggested makeup, as I understand it, is that there's APS workers on it, the power to compel the information, if it is just APS workers, where would that conflict be?
I might have to take this question on this, but my understanding of how the CIRB works is that there will be a pool of experts from which they will be drawn to put together a group.
Sorry, I beg your pardon. That's like so you've got your board, but then the board can go and get expert advice from a panel of experts.
That's my understanding. And not just get advice, but also my understanding is that the panel will also be very much intimately involved in investigating the issue that the board has been tasked with investigating.
So how would you fix that problem?
There has to be very clear, I think, guardrails in respect of managing conflicts of interest. Deputy Chair, you earlier mentioned the US Cyber safety board, I believe. In that case, there are clear safeguards to manage situations where a member may have a conflict of interest. For example, we're talking about situations where there are reviews that involve examinations of the employer's products or their competitors. In such cases, members will need to declare potential conflicts and they need to be recused from participating in review. Also, that I understand that all members of the US Cyber Safety Review Board would need to submit extensive financial disclosure reports and adhere to ethics standards that are pegged to the level of federal employees. So even the private sector members have to adhere to these standards. So yeah, guardrails are very much in place. I think if you look at the bill as it's currently drafted, what it states is that it doesn't really mention any resolution of conflict of interest. There is only disclosure of interest by members, I think, that's mentioned in the bill, which is very vague.
The explanatory memorandum does say that the members of the board that sit on the board will be from the public service appointed by the minister. Just clarifying that with you.
Thank you very much for that.
And just clarifying that you are of the view that composition should be more broad.
Yes, that's our to the extent that the board itself currently is comprised only of federal employees. We certainly think that there is value in having experts from the private sector as well on the board itself. So in a makeup that is a bit more similar, I guess, to the US Cyber Safety Review Board.
Provided the conflicts are appropriately managed.
Of course.
Yeah. All right, how are we going for time? It's 11:54.
A few more minutes, Deputy Chair.
No one else wants to have a crack?
Not at you, but no, they don't have any questions, if that's what you're referring to.
Yeah.
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 All good. Keep going.
Thank you. Just in relation to the Intelligence Services and Other Legislation Amendment Cybersecurity Bill, Mr. Shen, the explanatory memorandum states both industry feedback and ASD's operational experience indicates a declining willingness from entities to share technical cybersecurity incident, network telemetry and vulnerability information in a timely fashion with ASD. Has this been your experience? And if so, what do you think is driving the decline?
That's a very good question, Deputy Chair. What we have heard from our members, and I believe this was also mentioned by some of the previous speakers, is that a lot of this information that goes to the relevant authorities is very much one way. I mentioned earlier the importance of communication, the importance of public-private partnership. Communication cannot simply be one way, two ways. And going back again to what I mentioned earlier about a lack of perhaps transparency on how the information will be used, I think one of the ways of encouraging companies to come forward with more threat information is to be more transparent about how such information is being used, which agencies it's being shared with. The reform measures have gone some way in trying to address the concerns from the businesses. You look at the use obligation, that's really at the heart of things as well. But more can be done.
But is that your experience, or is that the feedback that you're getting that there is that reluctance?
Yeah, it's the feedback that I've been given. Basically, what I mentioned earlier, that a lot of things go to the government and nothing really comes back to the private sector.
Yeah. Do you think that the proposed limited use obligation, reflects and adequately deals with these concerns? And do you have any other outstanding concerns that haven't been addressed in the legislation in relation to the limited use?
We think that the limited use obligation is a good starting point. The policy intent behind the limited use obligation is something that we very much support. Of course, in terms of what more can be done, transparency, more communications between the public and private sector, and not just from the private sector to the public sector. That is what I would emphasize.
Yep. Good. Got it. Excellent. You have been very, very helpful today, Mr. Shen. Thank you so much, and thank you, Chair.
Thank you very much, Deputy.
Thanks a lot, Deputy Chair, and thank you again to our witness for making the time from Singapore. Thank you. Also, I should mention again, as there were a couple of questions that were taken on notice, we do require you to get in touch with the Secretary by 4 p.m. Canberra time tomorrow. So if you're able to do that, that would be fantastic. We'll also send you a copy of the transcript of today's evidence and also give you an opportunity to request any corrections should there be any errors. Now, on that note, we're going to suspend and have lunch, well, the lunch break, I should say, and resume here at 2 p.m. Thank you very much, everyone.
Thanks,
Thank you
Chair.
very much for having me.
Thanks, Mr. Shen.
Yep, cool. Okay, well, welcome back, everyone. Hope you all had a good lunch break. I'd like to now welcome a representative from Palo Alto Networks to give evidence at this public hearing today. Now, for the Hansard record, could you please state your full name and the capacity in which you appear today?
Sure. Sarah Sloan, Head of Government Affairs and Public Policy for Australia, New Zealand and Indonesia at Palo Alto Networks.
Okay. Thank you very much for that. And as I've mentioned earlier today, although the committee does not require you to give evidence under oath, I should advise you that the hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses. Giving false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Due to the very short time frame that the committee is working within to complete its review and report back to the Parliament, could you please try and answer all questions or provide information to the best of your ability in evidence today, as further written answers will have to be provided within 24 hours if you do take any on notice. Now, I'll ask you, do you have an opening statement that you'd like to make? Okay, well, you have the call, and then at the conclusion, I'll start to ask you a few questions and hand the call around to other committee members.
Great, no worries. Chair, Deputy Chair, members of the Parliamentary Joint Committee on Intelligence and Security, thank you for the opportunity to testify on the review of the cybersecurity legislative package. Palo Alto Networks greatly appreciates the committee's commitment to advancing bipartisan cybersecurity policy and legislation in collaboration with industry. We also commend the Australian Government for its ongoing efforts to strengthen the nation's cybersecurity framework and for its collaborative approach in developing these important measures. My name is Sarah Sloan. I head up Government Affairs and Public Policy for Australia, New Zealand and Indonesia at Palo Alto Networks. And on behalf of my company, I affirm our commitment to working in partnership with you and your staff as you continue to address a range of critical cyber issues. For those not familiar with Palo Alto Networks, we were founded in 2005 and have since become the world's largest cybersecurity company, protecting businesses and government agencies across more than 150 different countries, including some of the largest critical infrastructure entities here in Australia. While our brand was initially built as a next-generation firewall company, we have significantly expanded our capabilities to meet the evolving needs of today's digital landscape. Our offerings now encompass comprehensive solutions in cloud security and posture management, security operations and attack surface management, as well as cutting-edge cyber intelligence, incident response and cyber preparedness. In addition, Palo Alto Networks has been at the forefront of integrating AI into cyber defence for over a decade, driving innovation to enhance detection, prevention and response. And more recently, we've extended our focus to securing AI itself, ensuring that as AI plays an increasingly central role in business operations, it remains protected from emerging threats. This evolution reflects our commitment to delivering end-to-end security services that protect our customers across every facet of their digital life. Palo Alto Networks also remains deeply committed to helping Australians embrace the digital world safely and protect their operations from attack. Our Threat Intelligence Division, Unit 42, has built strong partnerships with key allies and Australian government agencies, including the Australian Cybersecurity Centre, providing real-time intelligence to support swift response to emerging threats. We're also committed to nurturing Australia's next generation of cyber professionals through free and tailored education programs for all levels. To set the scene for our discussion today, I thought I would briefly outline the current cybersecurity threat landscape based on our global threat intelligence and incident response expertise. Our data shows that our adversaries are increasing in terms of their speed, scale and sophistication. Speed of the 1,000+ incident review response cases Palo Alto Networks handles annually, the time between initial compromise and data exfiltration is shrinking. In fact, in 45% of our incident response cases, data exfiltration occurred in less than a day after the initial compromise, meaning that defenders now need to respond in near real time. Scale. Our adversaries are operating at an unprecedented scale. In November 2023, we released a report detailing the extensive compromise of 24 Cambodian government agencies by 2 prominent Chinese advanced persistent threat groups, highlighting the immense scale of the cybersecurity threat we are confronting. And sophistication. Cybercriminals today are operating like businesses, complete with structures and hierarchies. A striking example of this is Silver Terrier, a Nigerian business email compromise group we observed evolve from a handful of individuals experimenting with malware to a highly sophisticated organisation of 400 members who were developing their own malware. I understand that you've reviewed our submission to the committee, and I'd like to take this opportunity to highlight 2 key areas of the reforms. The first, the ransomware reporting regime, and the second, the Cyber Incident Review Board. We fully support the revised ransomware reporting regime, particularly its focus on reporting ransomware payments rather than demands, as it strikes the right balance between managing regulatory burden and increasing government visibility. Our reports show that ransomware continues to rise despite law enforcement efforts, increasing by 4.4% in the first half of 2040, with the top 6 ransomware groups responsible for over half of all attacks. We support this measure as it will provide government with enhanced visibility into ransomware threats and strengthen its ability to disrupt adversaries more effectively. However, we recommend that government regularly review and adjust the turnover threshold for reporting business entities to ensure it aligns with community expectations and captures ransomware's impact, particularly on critical sectors like small to medium enterprise and non-for-profits. After all, we cannot fight what we cannot see. Turning to the Cyber Incident Review Board, we strongly support the Cyber Incident Review Board as it fills a critical gap by uniting government and industry to better understand major cybersecurity events. The collaboration with industry is invaluable for developing shared lessons and actionable recommendations to improve responses across both public and private sectors. As a founding member of the US Cyber Safety Review Board, we've seen firsthand the value of industry engagement in providing real-time visibility into emerging threats. And we urge the Australian Government to include cybersecurity and incident response firms as standing members of the Cyber Incident Review Board, or at least to ensure and explicitly ensure industry involvement in reviews. This would strengthen the Cyber Incident Review Board's ability to address the fast-evolving cyber landscape with its strategic and global insights, but also build trust and cooperation with the private sector. I now welcome any questions you may have on these topics or on our broader perspectives on the cyber legislative package. Thank you.
Thanks for that very much, Ms. Sly. And you're happy for us to table that opening statement so we can get a copy to our committee and committee members. And thanks again for appearing before the committee. I understand and going through your submission to the committee, there's a bit of time that's spent, I guess, on the board, the CRIB, and I think as first principles, you agreed that it should be established. Are you able just to elaborate as to why? I mean, given we have had some conversations this morning from some witnesses. Suggestion either way, but I was just interested to get a good understanding from your end why you think it's important to have that review board.
Yeah, sure. So we believe that the Cyber Incident Review Board is really important for developing that shared kind of narrative around cyber incidences and shared learnings and outcomes. So a couple of key points I would say in response to why it's needed. The first is that it is an independent review board. So that's critically important, as you can imagine, if we're looking at cyber incidents affecting critical infrastructure as well as government, that review board has the ability to operate somewhat at distance from the other government organisations and provide impartial findings on how we can learn from those incidents and manage our cyber policies and postures going forward to prevent them from happening in future. The second component here that I think distinguishes the Cyber Incident Review Board is the industry involvement. So the ability for government to work hand in glove with industry, and I would say particularly cybersecurity and incident response firms who have that global visibility of cyber threats, but also deal with thousands of incident response cases across multiple sectors. So, critical infrastructure, telecommunications, banking, finance, and so on. So being able to draw on the insights that private sector has in terms of how incidents are playing out and what we can learn for future prevention. And then I think the third part here is around the policy development that comes from the learnings, right? So we're looking at the Cyber Incident Review Board, we're developing a shared understanding of how it happened, what could be improved, and then the implementation and adjustment of policies to ensure that that doesn't happen again in the future. So a really important mechanism, I think, for Australia going forward in terms of learning from cyber incidents.
Yeah, and I think the benefits from having something like that, given the context maybe around the world, when you look around the world, you see different models in place. Do you think this would be a very good standing for Australia to show the rest of the world that we're taking this issue very seriously?
Absolutely. I think the Cyber Incident Review Board is important for, sending a signal to the private sector in Australia that the Australian government is committed to public-private partnerships and that they are working, as I said, hand in glove with the private sector. It's if we're going to ask industry to improve their cybersecurity posture, we've got to have them inside the tent. We've got to listen to them. We've got to understand what they're seeing and how they're adjusting their posture. And I think the review board does go a long way to do that. And that's certainly why we'd be advocating for a more prominent position for industry. I note that the board is currently comprised of a chair, and some board members, as well as an expert advisory panel, like where you can pull in 1 to 2 or more industry experts to support the findings. We'd be encouraging government to have industry as standing members of the board, or to have an explicit kind of requirement to engage industry in every review. And I think that's really important, because we don't want to see the scenario where industry is pulled in to do reviews on critical infrastructure or industry incident responses, but it's not for government. I think that would go a long way to, kind of building trust if, industry were engaged in both reviews of government incidents as well as critical infrastructure.
So then, just following on from that, why can't then the role of the board be fulfilled by any existing government body?
Sorry, I missed that?
Why can't it be fulfilled by any existing government body?
Yeah, so I think the difference here, for starters, there are various mechanisms. You've got the Australian Signals Directorate, you have other functions across government that could look into reviews. But I think the defining factors here are, one, I guess if it was easy to do, we already would have done it. So I think that itself points to the need for a new review board. The second point is, once again, the independence of the board and the importance of having something that sits kind of outside of government to undertake these reviews with some level of impartiality. And then the third component there, of course, is the industry involvement, the explicit requirement to engage industry in these reviews to provide that industry lens, as I said, the expertise from cybersecurity companies and the like.
Yeah, this morning I think we had one of our witnesses, and it's their right, but just claiming that this role could be fulfilled within other government agencies, and I was just interested to see what your thoughts were, given that they were also claiming that industry thought it wasn't needed. So I just wanted to get on the record that you have the counter view, which is no, it is needed and it's important for the reasons you've just outlined.
Yes, no, we believe it is needed and it is important. And I note that on the back of other significant cyber incidences, we haven't had public write-ups of those, kind of post-incident review findings and policy outcomes. So I think that again points to the fact that this body is needed. And
you mentioned earlier about the rapidly changing threat in the landscape you outlined. Do you think though that it's imperative then to pass this package of legislation as quickly as possible? Any delay might result in people trying to have an opportune time to cause havoc or harm to our national sovereignty if we are not passing this piece of legislation anytime soon.
I think that the legislation should undergo a proper review and diligent processes. It is a quite significant piece of legislation, and I think from our company's point of view, we would encourage the Australian government to make sure it does do its due diligence in reviewing and making sure that they are the right instruments and right policies to be implementing.
But you'd like to see it passed soon rather than later, I guess, is my point.
I think once the review process has been done and everyone's done due diligence over the legislation, yes. Well,
we'll be reporting very soon to Parliament, I can assure you of that. And also, I wanted to ask you, the feedback that you've had, the consultation process that you've had to go through with respect to this package, has it been extensive from your point of view?
So we have been working with government since early in the year on this legislative package. So the Department of Home Affairs did go out for consultation. I think it was in early, maybe March, February timeframe. And we did, yes, and we did respond to that call for views. Since then, we have had subsequent engagement from the Department of Home Affairs, who I know have done best efforts to kind of engage with industry on these legislative packages.
And had you been involved with since the strategy was unveiled back in December 23?
Correct, yes, I have. So yes, and prior to that, I guess that's a good point, the legislative framework was signalled in the 2023-2030 cybersecurity strategy, which we were also part of a consultation process on.
And I know we've got a very short time frame, as I mentioned. Is there aspects of the bill, like for instance with the ransomware reporting regime that's been proposed, that you see merits in, that we need to, as part of this process, look at a bit further, or are you happy with where we've landed with the current drafting?
So we're largely supportive of the ransomware reporting regime. We think it does strike that balance between needing to enhance government's visibility of the ransomware threat, but also managing the regulatory burden that already exists with incident response, incident reporting requirements on particularly critical infrastructure entities. And we do definitely support the reporting regime with a turnover of the 3 million, which does align with the Privacy Act as a appropriate threshold. But as per my kind of opening statements, we would encourage the government to continually to review that to see if it does align with community expectations and does give them that greater visibility of the ransomware threat as it is impacting Australia.
I guess at the end of the day, it's the industry's expectations, and I'm assuming from what you're saying that people are generally comfortable with where we've landed so far, acknowledging that that figure is not in the legislation package, but it's something the government's committed to once we do pass the piece of legislation through the Parliament and through that consultation process.
Certainly from our company's point of view, yes, we are comfortable with the 3 million turnover. But once again, we would encourage, kind of continuous review of whether it needs to be a lower reporting threshold to capture a wider part of our economy.
Yeah, and I think it's fair to say a lot of these type of issues, the governments are always constantly reviewing and looking into, I guess. But now I'm going to hand the call over to the Deputy Chair, and hopefully he will log in or jump on soon.
I'm on.
You're on? G'day, mate. All right. Mr. Wallace, you've got the call.
Thank you. Just let me get organised. Thanks for your appearance today, Ms. Sloan.
No worries.
I just want to kick off with the Cyber Incident Review Board, and on a number of occasions today and in your submissions you've talked about the significance of the independence of the board. Do you think the provision for the Minister to approve the terms of reference for any review conducted by the board will undermine the board's independence?
I think that the board's independence is critical to its functions. As I said, it kind of is a distinguishing factor of why we have a Cyber Incident Review Board being established, is that it is able to operate at arm's length to undertake reviews of government agencies if they experience a cyber incident review, but equally to operate at arm's length when they're looking at reviews impacting critical infrastructure entities.
Yeah, that didn't really answer my question.
I think it's important that the board operates with a degree of autonomy and independence.
Okay, thank you. Do you have any concerns regarding information sharing with the review board, particularly around confidential or sensitive commercial data?
Yeah, I think that in the course of their investigations, it's possible that the Cyber Incident Review Board would gather commercially in confidence or particularly sensitive cybersecurity details and information. I believe that that can be managed in terms of conflicts of interest. We've already seen in the United States context that, various members of private sector, for instance, if there is a competitor involved, they usually can recuse themselves. In the US context, I know they have dedicated legal counsel to help, particularly the private sector members manage those conflicts of interest and manage some of the confidentiality requirements relating to that information.
So the difference, as I understand it, between the US model and what is being proposed here in Australia is that the CIRB in Australia will be sat upon by, according to the explanatory memorandum, Australian public servants, whereas the US model is sat upon by industry experts. So it's a bit of it's a little bit of a catch-22. If you don't have industry experts on it and it's only confined to public servants, then you're unlikely to get those conflicts of interest with commerciality. But then one, I think, could reasonably question whether if it was just sat on entirely by public servants, that you're not going to get our best and brightest at the table. And no offence against APS public servants, but they may not necessarily be at the coalface, such as organisations like your own. So that tension between the two, if I can call it the public model and the private model, is there a hybrid that we should be looking at that's sat on by
it has APS members, it has academics, it has industry experts, but then any commercial and confidence conflicts that could arise could be adequately dealt with by way of appropriate disclosures and people recusing themselves, etc.
Yes. So my understanding of the
very long question on my part.
Sorry. My understanding of how the Cyber Incident Review Board would work in line with the proposals is you would have a chair who's appointed and then your standing members, as you say, who would be APS employees, and then you would have expert members of like a panel, and at each point an incident review is kicked off, you could invite one or more members of the industry kind of expert group in to be part of the review. From our perspective, the concern there is that there isn't private sector representation on the standing member side of the House, and that maybe there would be merit in exploring whether all the standing members should be APS or whether there should be a fusion of APS with private sector members. In terms of managing conflicts of interest and the like, I do not think that that is an insurmountable hurdle. We've already seen the US manage this quite effectively. You know that they've undertaken 3 reviews to date, and in all cases they've managed, you know, the conflict of interest issues appropriately. As I said, we were a founding member of the Cybersecurity Safety Review Board, and our representation on that board, they have recused themselves from particular investigations where they believe there has been a conflict of interest. So I think, you know, undertaking legal reviews, getting legal counsel, managing those conflicts, recusing people, all of this builds a picture that it isn't insurmountable to have representation from cybersecurity and incident response companies, even in cases where they might be asked to review their competitors. We have established processes and mechanisms that can manage those scenarios.
Do you know why the bill has been drafted in such a way that, like, what the rationale was in having the members on the board as APS members only?
I think that would be...
Was it to counteract the potential conflicts issue?
Probably a matter for government, but my points would be that potentially having an expert panel would allow you to draw from multiple different points of view, depending on the nature of the incident that you're addressing. So whether you're able to pull in, you know, kind of particular legal advice, etc. My point on that would be that cyber security companies and incident response companies such as ourselves see incidents occur across the whole of economy. So we're not here as a telecommunication company dealing with incidents that affect telecommunication companies only or our own business. We're not seeing incidents just from one particular vertical. We are seeing them occur across the economy and globally. So we believe that there is merit in exploring whether standing members should be cybersecurity and incident response companies who can provide that kind of global view, whole of economy view of cyber incidents as part of the review board.
Yeah, okay. All right, that's good, thank you.
You're welcome.
The threshold for the mandatory reporting for ransomware, you say that you essentially agree with the $3 million threshold that's been set. It aligns with the Privacy Act, but I think you also indicate or have indicated in your oral evidence that this is not a set and forget, that this is something that could be developed or changed over a period of time. That's probably my words, not yours, but I think that's the gist of your evidence, isn't it?
Yes, that's correct. So at the time of consultation, the government was determining whether the threshold should be 10 million businesses with a turnover of 10 million or more. And then our feedback to government was that it should align with the Privacy Act, which has organisations captured with a turnover of 3 million or more. And we suggested that for 2 key reasons. One is to reduce regulatory burden, so aligning regulations between the 2 legislative regimes. But the second one was to increase visibility for government agencies so that they can have that better visibility of ransomware threats and payments. I think, sorry, and to your last point, yes, I think our submission is that it may be worth regularly reviewing whether that 3 million turnover should actually be lowered depending on the objectives of the legislation. So if the objective of the bill is to achieve greater visibility into the ransomware threat as it pertains to Australia, then there may be a need at some point to lower that threshold to capture a larger part of our economy. I think in the government's own documents, it states that the regulatory regime as it's currently set, if it was to be 3 million, would capture something like just over 6% of the Australian businesses, registered Australian businesses. So I think just planting that seed that while it might be appropriate to set it at 3 million now, whether there's a need to review this going forward to capture a wider portion of our economy.
Yeah, good, thank you. In relation to the managing consequences of impacts of incidents on critical infrastructure assets, you referred to your submissions in 2020 and 2021 that Palo Alto continue to remain concerned about the exclusion of merits review for Part 3A of the Saki Act. Do you want to just expand upon that a little bit more, please?
Sure. As the bill is currently drafted, Part 3A excludes any measures as being reviewed by the Administrative Judicial Review Act, so it's exempt from the ADGR Act review process. What that means is that should we or any other critical infrastructure entity disagree with a particular course of action or direction that's been issued to us by government, we do not have an independent legislative appeal right. I acknowledge that the Constitution in Chapter 3 has an inherent or natural justice right where we would be enabled to seek judicial remedy, but I think the Law Council of Australia has quite well articulated the fact that that has some limitations and it isn't a replacement for a review right in line with the ADGR Act.
And this may be a question best put to a government witness, but what's the rationale, as far as you're aware, in excluding the ADGR right merits review?
Yes, I would definitely be asking government that question, but from our point of view and what we understand to be the case, it would be that time constraints would be the concern, their predominant concern. To that, we would say that there is a possibility of managing an incident and dealing with a time-sensitive matter, addressing that, and then having some post-review process where industry could be brought in to review whether that was an appropriate, proportionate and reasonable request or direction on behalf of government.
That's probably all I've got time for, Chair, so I think I'll leave it there. Thanks very much, Ms Sloan.
That's right. I mean, if you had a few other questions, you're more than welcome to, mate. We've still got a few extra...
we've only got 2 more minutes.
That's all right. Look, it's fine, Andrew. Even if we're... okay. Yeah, it's fine. Like, if now's the time to ask, because otherwise, given the tight time frame, I'd rather you have a few extra minutes than bash me over the head later and say, why didn't you give me extra time? But anyway, go for it. Just go for it.
I would never do that.
I know, you're a good man.
Ms Sloan, can you explain to me the concept of zero trust? What's meant by that?
So, yes, zero trust is a kind of prevailing cybersecurity principle. It's not a product. You can't buy zero trust. It's a kind of way of thinking about cybersecurity. It has got a lot of traction in the US context. We saw an executive order coming out of the Biden administration some time back. And we recently saw a very welcome mention of the importance of zero trust in the cybersecurity strategy, the 2023-2030 cybersecurity strategy, when it talked about the importance of implementing zero trust across government networks. Zero trust effectively means it's removing implicit trust in networks and asking you to validate security and validate identity at every point in the process. So rather than just relying on, I guess, your front door and saying that initial check of who are you, should you be coming in here, at every stage of interaction in your technology suite and your environment, you are validating that that person has the right or the right privileges or these kind of things to ensure that they should have access to that particular type of data.
Okay. That's good. Thanks. That's all I have, Chair.
You're welcome.
All right, good on you. Thank you very much, Deputy Chair. Just checking any colleagues. No other questions. Excellent. Okay. Well, on that note, can I thank you very much, Ms Sloan, for your time this afternoon. And thank you for being very efficient with your answers. Now, if there were any that you did take on notice, we do require you to come back to us via the Secretariat by 4 p.m. tomorrow. And we'll also send you a copy of the transcript of your evidence and have an opportunity to request any corrections should there be any errors.
Thank you.
On that note, you're free to go. Thank you very much. Now, we'll quickly suspend and get ready for our next lot of witnesses, which is a business panel. Thank you. Okay, hello. Welcome back, everyone. Now, we've got I'd like to welcome representatives from the Business Council of Australia. Sorry, my eyesight's not great. Who have we got there? Oh, we go, Mr. Mike Barija? Barija, thank you, Mr. Barija, from the Council of Australia. We've also got the Australian Institute of Company Directors and the Council of Small Business Organisations Australia to give evidence at this hearing this afternoon. Now, for the Hansard record, could I please ask that you all state your full name and the capacity in which you appear before the committee? And we'll do it one by one because we don't want to have a chorus going, but we'll start with you, Mike. You're here in Canberra, so off to you.
Great. Mike Barija, Director of Digital Technologies, AI, Cyber and Future Industries at the Business Council of Australia.
Fantastic. Now, the Australian Institute of Company Directors.
Good afternoon. Christian Gerges, Head of Policy, AICD.
And Simon Mitchell, Senior Policy Advisor, AICD.
And the Council of Small Business Organisations Australia.
Yeah, good afternoon, Chair. Luke Actor-Strad. I'm the CEO at COSBOA, which is the Council of Small Business Organisations Australia. Thanks for the opportunity.
You're most welcome. I probably should say that COSBOA. It's probably easier. Now, thank you for all of you for providing a copy of your opening statement. If you're happy to, I would like that we agree to table this and incorporate it into Hansard, if that's okay. I understand, Deputy Chair, you're happy to move that way?
Yeah, that's fine, Chair. Happy to move that.
Thank you. It will save us about 20 minutes. Otherwise, if we give everyone 5 minutes each, we'll consume half of our time. Having said that, was there anything that either of you gentlemen wanted to say that in addition to your opening statement? Business Council Australia, was there anything in addition, like briefly?
No, not in addition, just making note of the engaged and genuine consultation that Home Affairs undertook on this legislative package, and we welcome that.
All right. Well, I might even ask you a question about that later on. From COSBOA, was there any in addition to your opening statement?
No, nothing in addition, Chair, but just to emphasise some of the initiatives the government's pursuing around the Cyber Executive Council, programs like Cyber Wardens, trying to actually emphasise training, awareness and education as opposed to punitive measures. That's in our submission, that's in our opening statement, but just to acknowledge those key themes today, so thank you.
Okay, and the Institute of Company Directors?
Thank you, Chair. So just to reiterate the close collaboration and consultation from Home Affairs with industry on these reforms, and our real urging and support for a Team Australia approach, which recognises that we can't really build collective resilience without all parts of the ecosystem working together. So emphasise just that point, and I'm very happy to take questions.
Okay, excellent. All right. Well, on that note, if I might ask the Institute of Company Directors, your submission recommends that SOCI Act entities be excluded from ransomware payment obligation, given the existing notification requirements in the Act. Now, this is something I think that's been mentioned by other submitters as well. Could you just go into some detail about this for me?
Thank you, Chair. It's not so much excluding SOCI entities, it's more just avoiding duplicative reporting. Our interpretation of the drafting of the bill is that, in effect, a SOCI entity would report a ransomware incident and the payment associated with that incident twice. So firstly under the SOCI Act notification obligations, and then separately under the ransomware payment obligations that are proposed in the bill.
Yep.
I guess informed by our feedback from our members, that, you know, we try to avoid, or would like the government to avoid, duplicative reporting where possible. And ideally, we think, you know, minor amendments to the SOCI Act could enable a SOCI entity to just report the ransomware payment under those existing notification obligations.
Okay. Well, thanks for clarifying that. So what you're saying is the instead of reporting twice, you'd report once.
That's right. That's right. We certainly don't want to exclude SOCI entities from the ransomware payment obligation. It's more just incorporating ransomware payments, or specifying that a ransomware payment is a notifiable incident under the existing SOCI Act obligations.
And just for clarity, what's your preference then in terms of reporting?
So for a SOCI Act entity, they would just report the ransomware payment under the existing notification obligations.
Okay. All right. All right. Now, in terms of the Business Council of Australia, let me just have a look here. What, with respect to Australia introducing security standards in respect of the IoT devices, can you just elaborate a bit further about why you're supportive of what the government is intending to do?
Of course. So IoT devices are now almost ubiquitous across our households and our businesses and across the economy. It is a huge threat vector. These are like open doors into other networks. They are something that is generally a soft underbelly in many networks. So it makes sense that now in this changing technological environment that they are so prevalent that we address that vulnerability. So, you know, the ability to take what is working overseas, and in this case the UK model has been referenced, makes sense. We don't want to reinvent the wheel, and we support that kind of implementation of a minimum standard for these security standards for these devices.
And your support for the proposed approach of the Department of Home Affairs, that the initial standard, I guess, would match the requirements that have been imposed in the European Union. And you may have heard some early discussion, but I'm assuming you're also supportive of what the EU and others are trying to implement?
So there's always a middle ground. And so being able to, I think in this regard, because it is such a big space with such a diversity of the types of devices that are connected, we need to start small, which is where it seems to be indicating that we are starting. So being able to put in those really basic requirements around not having default passwords, for example, is somewhere we need to start. But if we are looking at the ambition that's kind of hinted at within the cybersecurity strategy and looking at moving into making this secure by design philosophy embedded in everything, from devices to even large software suites, I think we need to get our sea legs, so to speak, first of all, and start small. And I think that's the right approach.
And you may have heard the earlier discussion too with respect to the review board. You're also supportive of that?
Yes.
Yeah.
We are supportive of the Cyber Incident Review Board. We think it's going to be a timely and very valuable addition to the cybersecurity architecture that we have here in Australia. We do have a couple of concerns about some of the details. So, as was mentioned previously, it seems like the proposed model of having a APS-staffed board and then a expert panel is probably suboptimal. We would strongly recommend that the standing members have a mix of industry, government and civil society. And if we are looking at that model in the US of the Cyber Safety Review Board, that does have 15 standing members, 7 of which are private and 8 of which are public service. So something along the same kind of proportions would be welcome. Even pushing it a bit further, I would say that the majority should be of non-government in order to bring in that expertise and provide real independence for that entity.
Okay, thank you. Now with COSBOA, I do note your submission, you note the government's might limit the adverse impact of cybersecurity legislation on small businesses, and why you're generally supportive of the policy intent of the package. I was just hoping you might be able to elaborate for the benefit for me and the committee why you see there are benefits of the government's attempts to reform these cybersecurity laws.
Yeah, absolutely, Chair. I mean, the first thing to say is the front and centre nature of small business in the National Cyber Strategy, to me, is really positive and really encouraging. So when you look at the way in which you've got, I think it's 6 or 7 cyber shields, what's number one? It's small businesses and it's consumers. So it's people who are out there every day, opening their Facebook, opening their Instagram, banking online, engaging in the cyber world. That's 98% of our economy are small businesses. So that recognition alone, that small business is really front and centre in this narrative, and this Team Australia approach, as Mr. Gerges mentioned, has sent a really positive signal to COSBOA and to the small business community. I mentioned in the earlier introductory remarks the Cyber Executive Council Chair. So actually having expertise roundtables at the highest level, and I think to the gentleman from the BCA's comments, having government and non-government expertise at these roundtables is really important. And COSBOA was very grateful for the opportunity to be a standing member of that Cyber Executive Council. So for small business to have a seat at the table, literally and metaphorically, in those conversations for us is really important, because we need our voice to be heard by government, but also by a lot of those large enterprises, Chair, who run the telcos, who run the apparatus, who run the infrastructure. More specifically on the legislation, obviously a legislative framework is really important. Obviously we need to provide as much guidance as possible. There has been pretty strong consultation on the package. As you note in our submission, we are very supportive of the intent of the policy. As you would have seen, we remain concerned about a couple of items in that list which pertain to the threshold. And we can certainly have a discussion about that. And not unsurprisingly, in regards to the fines, the punitive measures on the table for small business, which we feel would actually be counter-intuitive and contrary to the policy intent of the package. But certainly, small business is up for it, Chair. That's where there's a lot of work being done at our own behest, programs around cyber awareness, around cyber security. Small business has identified the risk of a cyber attack as the 3rd biggest threat facing us at the moment. So selfishly, it's an issue affecting our people, but equally we understand we have a big role to play in that cyber strategy. So that's why we welcome the broad direction of where the draft bill is heading at the moment.
Yeah, and it's not just the hundreds of thousands of small businesses, also the people behind those businesses as well too. But and you mentioned about the consultation process from your point of view, and I'm not sure if you were involved since the cybersecurity strategy back in December 2023, but were you pretty happy with how the government's conducted the consultation process?
Yeah, I'd say the consultation's been satisfactory, Chair. It's certainly been, I think, timed relatively well. We haven't had the feeling that government has been seeking to ram through any pieces of legislation without opening a can of worms. There's obviously other portfolios where COSBOA will have strong opinions about the ramming through of certain policies, but certainly with regards to cyber, we feel it's been managed pretty well, and I think congratulations as well on the appointment of Michelle McGuinness, who I understand is appearing as a witness tomorrow. Her credibility and by appointing a senior person in the security world to engage with small businesses. Lieutenant General, came to the launch of some cyber research we did at the Press Club. So that sort of engagement, as well as your consultations, been largely satisfactory and remains ongoing, which is why we're here today.
Yeah, and I think BCA, you did mention something at the start. I don't know if you wanted to tack on to what Cosboa just said about the consultation process.
This has been a great example of how to do consultation right from government on large-scale, complex kind of legislative reforms, going back all the way to about 12 months leading into the release of the strategy, which was in August 2023. I know that Home Affairs representatives had consulted across Australia face-to-face with businesses from all sectors, leading into the development of the policy and legislative recommendations in the strategy, which have eventuated into what we're talking about today. The BCA has also had opportunities to provide previous submissions to both the strategy and the exposure draft. And indeed, in August this year, we worked with Home Affairs to conduct a town hall for our members, which was purely to facilitate Home Affairs' desire to deepen their communication with industry to make sure that the implications and the joint development of these legislative reforms was undertaken. So overall, that's a good news story.
Now, can I just turn to another matter, to the company directors first? It was in relation to some other discussions we had this morning with respect to the reporting obligations threshold, and I do note in your submission, I think you mentioned a $10 million figure rather than $3 million figure. And we'll just get you up on the big screen.
That's correct.
Yeah,
we suggested 10 million.
Yeah. Now, can I ask why? I asked why, but then do you think that this could be an issue given lack of alignment with the threshold would see a number of small businesses or the definition of small businesses not being aligned to or being consistent with the Privacy Act?
Yeah, thank you for the question. And I guess just quickly, we do share the concerns of Cosboa that $3 million is very low. I think thinking about the nature of businesses or organisations of that size, I think it's not hard to extrapolate their challenges around resourcing, capacity, time to understand that they've experienced a ransomware incident, potentially make a payment and then be aware that they've got a ransomware reporting obligation within 72 hours. I think we see there's significant challenges there in terms of raising awareness, not to mention, potentially punitive enforcement outcomes where they'd also be penalised for not making a report, when they weren't even aware they had the obligation. Chair, we suggested $10 million based on that was a threshold that had been suggested by Home Affairs in the initial round of consultation. We thought that was an appropriate level. It's not an exact science, picking these thresholds. It was more a sense that organisations of $10 million and above are likely to have resourcing or have access to resourcing advisors that can inform them that they have that ransomware reporting duty.
So is it the vibe of the thing, but the $10 million? Like, how did you get to the $10 million figure?
It was based on that Home Affairs proposal that $10 million was the initial threshold that had been proposed.
Because there's not an actual figure in this package. There's been probably discussions around figures, and I think the proposal maybe at the moment is about 3, but I was just wanting to get a good sense from your end why the 10. But look, thank you for mentioning that. Can I also ask Cosboa, well, if I could reiterate the same question to you, in light of what you maybe heard, if you wanted to add anything else, because I think in your submission you do mention that as well.
Yeah, thanks, Chair. And look, you're right. In the Privacy Act, the small business threshold is $3 million, but you would probably be aware that that figure hasn't been indexed or reviewed in over 20 years. So we, as a starting point, we don't feel that that figure is fit for purpose. So therefore, we don't see logic in using that as a justification for a threshold in this package. We think there's scope to update both of those. We agree with $10 million. You'll note that the ATO, the Australian Tax Office, who holds a special place in the heart of all small businesses in Australia, that they use $10 million as their threshold for small businesses. So it's quite a well-established, well-understood figure, and that's what we support as well in regards to some of the matters there that the AICD referred to. We're talking about firms that don't have heads of security, heads of cybersecurity. We're talking about firms who get a lot of their information from their bookkeeper. We're talking about firms who are telling us they're facing really high stress and anxiety about the prospect of a cybercrime. So we feel really getting that number right is really important. But Chair, back to your, I suppose, broader question about consultation. Yes, you're right. The figure is not necessarily in the package at this point in time, which I think does enable these conversations to be constructive and to try to land on a more realistic figure.
And, in light of the government's current conduct about consultation, I'd be surprised if that wasn't to continue on this matter. But and I think there's good reasons why it's not in the package. But look, I just wanted to ask you too, though. I don't know, BCA, if you have a view on the figure or not.
We haven't made a statement on the figure in our submission. However, I do understand the concerns put forward by my colleagues here today. I think that it's very important to keep in mind as well the equation, so to speak. So it may be that there is undeniably a regulatory burden and a lack of capacity to respond for a lot of these smaller businesses, but you would hope that the data collected and the insights gathered by government do go back to small businesses, especially to help them combat this threat. So keeping in mind that that is a trade-off there, and we hope to see better outcomes from government and better ways to address this.
Yeah, I guess from my end, I just want to make sure there's not a lack of alignment. It's as you probably appreciate from Cosbo's point of view, all the different rules and regulations you've got to deal with, but making sure there's a consistency across the board rather than having all these different rules on different pieces of legislation. Anyway, but put that to one side.
Chair, may I just come in on that?
Sure.
To be honest, there are differing reporting thresholds across Commonwealth legislation. So while alignment is good, there are lots of different thresholds for lots of different reporting obligations in a range of areas. So I do think having a case-by-case approach, I think it's not good policy if you have the threshold set so low that entities don't even know their obligation exists, and therefore there's going to be potentially widespread compliance. That doesn't really help anyone, and hence, Cosbo has obviously emphasised that point around trying to lift their capacity and help them to build their resilience rather than focusing on creating another obligation where at a time when small business is obviously under quite a bit of significant stress.
Yeah, but on that though, I'd also ask then, wouldn't be on industry, on bodies like yourselves, or three today, to also educate your members, provide a service to your members. If people have an issue, like whether they be a member of an association or a like organisation, no different to someone being a member of a union or having insurance, you sort of call for help, right? So is that something that industry or business council peak bodies are maybe looking at trying to have as part of the services that you offer your members? You're a member, you pay a fee, or you do a course with the directors, company directors of Australia, but there'll be people here who can actually support you along the way with these issues. Is that something that, and this is probably more a question to all three of you, something you're considering as part of your ongoing services to your members?
Jump in first on that, if that's all right, Mr. Gerges.
Sure.
No, we're not just considering it, Chair, we're doing it. So we've actually rolled out cyber wardens, and credit to the Commonwealth Government, there's funding there for that program from the Commonwealth, but we're also working with Telstra, with the Commonwealth Bank, with the Cybersecurity Agency as well, in terms of Lieutenant General McGuinness. And that program is about not 50, not 60, but what are 5 or 6 practical tips for a time-poor small business owner to actually wrap their head around. So we're talking about prevention here rather than cure, Chair. So it's sort of, a bit of a preempter of what this discussion's about in terms of ransomware. But how can you, as a small business, do a bit of a crash course and implement some basic steps, be it password management, multi-factor authentication, device management, to actually mitigate that risk of an attack happening in the first place. And a lot of it is about awareness, Chair. A lot of our people feel that they're not vulnerable, that there's this fallacy of small and safe, because the newspapers tend to report the big end of town and the Medibanks and all those breaches, when in reality we know that small businesses are really subject to a spray and pray approach by a lot of the cyber criminals. So cyber wardens absolutely would be a cogent example of that. It's being distributed out through our membership bodies as well. As you'd be aware, COSBO is a peak of peak organisations, and it's similar to other programs we run. We've got Small Business Peak, which is trying to educate small businesses about the latest complex changes to industrial relations. We've got programs around boosting female participation in small business as well, but certainly the Cyber Wardens program has been specifically tailored to half an hour, 40 minutes for a small business owner to improve that literacy. And I agree with you, membership bodies exist for a number of reasons. Advocacy, beautiful moments like today appearing at inquiries, but also member services and member delivery. And members are at the heart of what we do. So we're pretty encouraged by this program so far. And as you can see, I'll take any opportunity to promote it. Thank you.
Well, you've done a good job. I think the Australian Company Directors, did you want to add?
Sure, thank you. I just thought I'd give a quick overview of some of our work in this area, Chair. So you're absolutely right. This is a huge focus of the AICD, and this is an area where board directors are very much leaning into this issue. They see it as an area where they need to be exercising effective oversight over their management teams. I should say in October 2022, we released the Cybersecurity Governance Principles in collaboration with the Cybersecurity CRC. That piece of work was endorsed by the then Minister, Claire O'Neill. We've had more than 25,000 downloads of those principles. They are actually freely available to anyone, Chair, so available both to members and non-members. Earlier this year, we followed that up with a specific deeper dive on cyber incident response and recovery, which we did again with the CRC and professional services firm Ashurst, and then a few months ago did a more dedicated piece around cybersecurity at the SME level. We also run a program of roundtables, webinars and events on cyber, which are very well attended, and many of those are free to members as well. So absolutely, we know we need to play a role in terms of awareness raising, and we feel like we are doing so and continue to do so going forward.
Yeah. I think in the, not I think, but I just having a look at the explanatory memorandum, I think in paragraph 222, the Home Affairs say, or the draft in here says that they would take an education-first approach to enforcement. So hopefully that might alleviate any concerns that you've just raised. And just lastly, before I hand over to the Deputy Chair, in terms of the reporting obligations the information that's required to be provided, let's say at the $3 million amount, do you think it's particularly onerous, given that the business only need to provide the information that they only come across, that they're aware of? I guess what they don't know, but in the instance that they do come across something, they just have to report what they've come across. Is that something that's too onerous from your point of view?
Well, I can say on behalf of BCA members who are usually large corporates with the capacity to dedicate resources to this, it is not too much of a burden, but that doesn't represent the entire economy. I think that the stresses felt by smaller businesses will make that sometimes a little bit harder to respond to, but I'll let my colleagues answer on that regard.
Yep. Cosbauer?
Yeah, thank you, Chair. Look, I think it is onerous, because we need to just recall here a small business owner is the head of marketing, the head of operations, the head of IT, the head of legal. I can keep going. And so it is very, we're very wary of when policymakers will analyse a particular obligation in isolation, right? So it's this cumulative impact of what we're seeing and the amount of new compliance and the amount of, some of it rightly, some of it in our view wrongly, but the amount of obligations a small business owner has on their plate, it is disproportionate as my colleague from the BCA alludes to, when you have a very different resourcing structure. Now, we also need to just understand the state of mind of the small business owner in this context. A lot of people in our research have told us there's feelings of shame, there's feelings of guilt, there's feelings of stigma in the event of a cybercrime. That influences and undermines the ability for that small business owner to act in what you might consider an otherwise, compliant manner, or dare I say, in a rational manner, for lack of a better term. We understand the mental health challenges that small businesses are facing at the moment. Small businesses, according to the latest Small Business Matters research from the Ombudsman, indicates many owners are actually paying themselves last. They're trying to put their staff first, and they're actually earning less than average weekly earnings. So what that I'm trying to describe here, Chair, is a sense of challenging environment at the moment, and this particular incident which may occur is a very emotional experience where a business may actually consider, will I remain solvent, will I need to close permanently, what's the reputational damage, and then to attach to that a 72-hour sort of guillotine with the prospect of, or window I should say, with the prospect of punitive measures, we feel creates a very a seemingly hostile approach, which would seem contrary to the explanatory memorandum, which talks more about education and awareness. So again, we come back to prevention rather than cure, but certainly I can't think of many small businesses out there at the moment who would tell me that more obligations will not be onerous when you look at how much they're currently dealing with.
Mm. Look, and I guess I'm not trying to get into a debate about the point, just ask the question, because my concern would be, as I said earlier, with the hundreds of thousands of small businesses around the country, last thing we want is a cybersecurity attack that impacts the vast majority of these employment places. So, all right, I'm just going to hand the call over to the Deputy Chair, who will probably jump up online within a matter of seconds. There
I'm
it is.
here, Chair.
All right, the call is yours.
Thanks, Chair. Look, a lot of the questions that I wanted to ask have been answered in some detail. So thank you very much for your appearance today. I think what you have done in the short time that you've appeared has really given the committee a very solid grounding on particularly Mr. Akhterstrad about the difficulties that many small businesses are experiencing right at this point in time. So thank you for your evidence, particularly in relation to the threshold. I think that's been really very instructive for us, at least for me. I probably shouldn't speak for anybody else, but I do want to just ask a few questions, and this might be an appropriate time for the Secretariat to maybe making, without telling you, had a CyberCX chair to be making some calls to see if we can bring the university sector online perhaps a bit earlier, because I won't take another half an hour.
Oh, I was going to say, are you suggesting that you might be finishing up your questions very soon?
Well, I reckon we could work on a 2:15 to 2:20 finish for me. So up to you, Chair, whether you want to just adjourn till and see how we go, or try and bring the others in.
All right. Well, look, you leave that with me. We'll see what we can do up here in Canberra or down here in Canberra, given you're north of us at the moment. But fire away with whatever questions you've got left.
Thank you.
And we can't see you at the moment. I think your video's off.
No, my video's on, but
that's all right.
Well, it should be on. It's telling me it's on.
That's all right. It's all good. Maybe a cybersecurity attack or something. Who knows? But anyway, that's cheeky. Fire away, Deputy Chair.
Thank you. Just going to the point you were all talking about earlier about the importance of education. I might throw this question to all of you, but I want to start particularly with COSBOA, but not just limit it to you. But do you think company directors are sufficiently aware of the risks posed by cybersecurity threats to their organisations?
Thanks, Deputy Chair. Look, my ability to comment on this with any deep credibility is limited given my limited exposure to company directors in this country, but certainly the engagement that I've had with the AICD to date has demonstrated a willingness to engage with the small business community. I have seen a lot of their materials in respect to cyber for directors and actually, having cyber awareness or cyber security as a part of that, what you might call that, the skills matrix of a board, right? What skills do you want on your board? Do you want to have a mix of skills and seeing that sort of cyber awareness coming to the fore? In my observations, that has been quite positive. If I'm talking about, I suppose, company directors, of self-employed businesses or smaller businesses.
That's what I had in mind when I directed the question to you. So the small business owners.
Yeah, absolutely. No, absolutely. I wasn't sure if it was a thinly veiled opportunity to comment on my colleagues at the AICD.
No, they can talk for themselves.
They can. They're big and ugly enough to. Deputy Chair, the research we've done, and I mentioned it in the submission, small businesses told us that after energy costs and after employment costs, the risk of a cyber attack is the biggest risk they face. So it's the third biggest risk. We know that a small business can lose up to $46,000 from a cyber attack. Deputy, the research we've done actually, this will tell you the story. At the moment, small business owners, small business directors, entrepreneurs, it's a bit of a 50-50 split, Deputy Chair. On one hand, the research came back and said almost half of small business owners are acutely aware. They're losing sleep about it. It's a perennial challenge, and they're thinking, how do I get more information? What do I do? Now, on the other hand, Deputy Chair, almost the other half turn around and say, haven't really thought about it, haven't really turned my mind to it. A little bit of the ostrich effect, and I'll deal with that down the track. I've seen a couple of media stories about it online with big companies, but it's not really. I'm a butcher's in Lismore. What would a state-sanctioned cyber criminal want with me? So you've sort of got this dichotomy at the moment, and what the research teased out was the 50% who are acutely aware, they're the ones who are talking about it. They're the ones who may know someone who's experienced an attack. They might have had a staff member experience an attack. They might have had a family member have experienced an attack, and they are talking about it and they are sharing those stories. So how do we get this, I suppose, relatively naive cohort more acutely aware, but in a sensible, informed approach? That's what we're...
Without them finding out the hard way.
Correct. So that's a lot of what we're trying to do about workshops, raising awareness, the program I've mentioned as well in terms of cyber wardens, but also trying to integrate a lot of these conversations about cyber, try to reduce some of the stigma as well. So in terms of, as an organisation, we're trying to open up those conversations because we found the more people talk about it, the more they gain a little bit of a sense of confidence to actually engage with these issues. And then that could potentially lead to better processes, even looking at conversations about cyber insurance. It's a whole separate, we'd have a long conversation about that, but actually trying to make them a little bit less intimidated by this and a little bit more empowered.
So for AICD and the Business Council of Australia, I'm assuming that your answer will be somewhat different to COSBOA, and perhaps I'm generalising, but I imagine that the awareness of the risks of cyber security issues are much greater. Do you want to talk to that, BCA?
Yes, so cybersecurity is front of mind for large businesses across Australia, and it's been that way for many years now. There was research done by PwC this year of Australian business and technology leaders, and 67% of those said that cyber risks is their number one priority for the coming year. So this is something that is well understood and well resourced in these organisations. However, there is still a need to make sure that the regulatory approach and the industry contribution to that is always done in partnership, and that we have the positive incentives and true collaboration, and even to a degree in some areas integration, to be able to make real differences in this cybersecurity problem. So while there is this awareness and this investment and this capability in the big end of town, it does still require this partnership model with government, and that is really well understood at the moment.
What does that look like, though? What is that? How can government help from an education perspective?
Well, from an education perspective, ASD and the ACSC already does a huge amount of outreach on both the more technical side of cybersecurity and on the more business-focused and business risk side as well. They actually also have a small and medium enterprise outreach facility as well. So, you know, things like the information security manual and the standards listed in there, the way to implement them, ASD and the ACSC do fantastic work there. But it's still, how do you have an ongoing partnership with that trust and confidence at the very foundation of it when you are sharing telemetry, sharing incident data, looking at remediation and recovery from events, looking at things like the Cyber Incident Review Board and how it will work? My view is that it really does need to be this empathy with the positions that these often victims hold, and making sure that it's those positive incentives that make sure that that collaboration continues, because both industry and government knows that alone, each one of them is not going to be able to make a huge difference here. It has to be together.
Okay, thank you. And Australian Institute of Company Directors, I imagine that your answer is going to be much the same as BCA?
Similar, but I'll be brief just to reiterate a few points. So absolutely, we've had a huge amount of member interest in uploading of our resources. As I mentioned, cyber governance principles, more than 25,000 downloads of those principles and associated resources. We've got various checklists. I look to, say, the SME audience. We have snapshots. Cyber regularly ranks as the #1 issue keeping directors up at night. We run a member survey twice a year, and cyber regularly tops that list. I should say, though, that we can't be complacent. We are, as an institute, updating our cyber governance principles. Version 2 of those principles will be released later this year. We've had very good engagement from various government agencies to make sure that the principles reflect their expectations, reflects better practice, and really we've got the wisdom of everyone in the ecosystem. This is an area where I think directors recognise you can't set and forget. What may be a relatively strong cyber governance approach 12 months ago may not be the case 12 months forward. And on the question of government outreach and collaboration, my colleague from the BCA has spoken about the Australian Signals Directorate and its outreach. Absolutely, that's a really important piece. We've done a range of different webinars, events, roundtables with them. They also run a very helpful partnership program where entities can agree to share information with the ASD and vice versa, which is really, I think, critical in terms of sharing information, building up that mutual trust, which hopefully can help stand everyone in good stead if there is a major incident. I should say as well, we haven't yet had any questions around the Cyber Incident Review Board, so I'm happy to make some comments on that at the appropriate time.
I was just about to go to that, actually. And I think one of you did actually comment on the Cyber Incident Review Board, and I was going. My very next question was going to be to you all. Would any of you like to argue against the proposition that the Cyber Incident Review Board should be sat on by not just public servants but by industry, by academics? I think it was the BCA gentleman that talked about the makeup with the US model being 7 private members and 8 public servants, and he thought that should be tipped around on its head. But
Does anybody? I think it should be. I think it shouldn't just be sat on by public servants, but it's not me to give evidence. I want to give you guys an opportunity to speak against that concept, because that's kind of where I'm headed, is where I'm sitting anyway.
Yeah, I'm happy to maybe kick off, and then I think the BCA and Cosbell may wish to jump in. So I agree with the proposition that you want a broad mix of experience and capability on the Cyber Incident Review Board. I think as well, the intention is that that review board assesses both an entity's response as well as the government's response. So I think it's important that there is from an independence perspective, there isn't a situation where, rightly or wrongly, there may be a perception that the government members are marking the homework of some of their colleagues, and I think that is something we want to try to avoid. The whole purpose of the Cyber Incident Review Board is to take a deeper look at major systemic incidents and to feed that back to build resilience for everyone. And so that's why we have strong support for the concept. I should say as well, there are some elements where I think it needs to be refined potentially, and that's where there is a point in the package where the suggestion is that the review board may consult with the impacted entity, and we think that should be a mandatory requirement in order to make sure that from a procedural fairness perspective, the entity has the opportunity to present its side of the story. We also think ideally these reviews should occur after relevant regulatory investigations or proceedings have concluded. Otherwise, you have this risk, which we know is quite a significant material risk in this space of various different potential regulatory investigations from different bodies. And we think particularly when an entity is trying to recover from one of these incidents, they're going to be dealing with a lot of different issues, including, importantly, recovering systems, setting them back up again. And we want to make sure that we're minimising that element, and that, you know, in due course, those issues are looked at in the cold light of day. And I think that's critical as well. And we also think if you want to have a no-fault principle, which we strongly support, and that's been clear from Home Affairs, that individuals are also captured, not just entities, because despite the intention to have a no-fault approach, I think in reality, depending on how the reports are written, there may end up being some kind of negative inference drawn about the conduct of organisations or indeed individuals within those organisations. So I might make those points, Deputy Chair, and pass to BCA or Cosbell to offer their thoughts.
Yeah, thanks for that. And I'm also keen to get your collective views on the perception of the impact on independence of the board when the minister is able to set the terms of reference of any inquiries. I'm keen to get your thoughts on that. Anybody?
I might start just by on the first point around the Incident Review Board. Totally agree with the statement there around mandatory consultation with entities around draft reports, and that's not only for the opportunity for those entities to identify any sensitive information that government may not have identified, but it speaks to this idea of a no-fault cooperative endeavour, and it's something that would be a really key part of giving a fair go to the victims to say that this is a way to build that trust and actually have true lessons learnt. On the second part, the ministerial approval of the terms of reference for the Cyber Incident Review Board, I know that could give a perception of that undermining that kind of independence. I would put my faith in the idea that this would be a approval with genuine consultation with the drafters of that terms of reference. So fundamentally, I wouldn't have a major concern with it.
Okay. Anybody else on that point?
Doesn't look
Cosbell?
Chair, yeah. Look, I'll just add in terms of the composition of the board, that would obviously, won't surprise you what I'm about to say, have really strong small business line of sight into that board. So whether the public servants, perhaps one of them should be the Australian Small Business Ombudsman to actually provide a line of sight into our community. Perhaps one of the industry reps is a small business person themselves or industry representative. So that won't surprise you. I think in terms of the independence of the terms of reference, not something we have a really strong view about, but to the BCA's point, I think obviously this theme of acting in good faith, the Team Australia approach, whoever signs off on the terms of reference is one thing, but the actual content, scope and robustness of those terms is probably the more pressing matter from our perspective.
Deputy Chair, have you got any more questions? I know you mentioned you might finish early, but I'm mindful that Mr. Gosling has questions, and I actually don't think we're going to start any earlier, so we may have brought forward unnecessarily our next witnesses, but...
Well, we'll just miss out on a 15-minute break. That's okay. I'll finish up there, Chair.
All right. Thank you. Now, Mr. Gosling, you've got some questions?
Yeah, thanks, Chair, and thanks, gentlemen. I rejoined the hearing a little bit late, so apologies if this was covered earlier. I'm up in Darwin, have enjoyed listening to your contributions. Just for the Australian Institute of Company Directors, I did hear your thoughts on the thresholds as an issue, but just more broadly, I was just wondering why you're so supportive of the ransomware reporting regime that's proposed by this bill. You know, happy for a short, sharp answer, but I'm really keen to get an understanding of why that broad support's is reasonably strong there for the reporting regime.
Thank you, Mr. Gosling. I'll reply to that. So we recognise that it's very useful for the government to have a clearer picture of the various different threats facing Australia and the different attacks that are being perpetrated on a daily basis. So in that sense, we understand the rationale for having a reporting obligation where there is a ransomware that has been paid. So I think having a better picture of the threat environment hopefully allows us to prepare better and to be as strong as possible in terms of responding if there is such an incident. Obviously as well, hopefully, we want to get to a point where organisations don't feel like paying a ransom payment is a good idea. However, we recognise this is really difficult. It's easy to say you won't pay a ransom in the abstract, but if you're in an entity and facing a significant impact, which could impact some of your potentially vulnerable customers, then the equation might not be as black and white as you might have hoped. So that's why we think getting a better picture of the prevalence of these attacks is really critical. And I think the government is trying to approach it in a sensible way, notwithstanding, obviously, our view is that the reporting threshold is set at too low a level. But Simon, did you want to add anything?
No, I second those reflections. Ransomware is a crime. That's been experienced by an organisation in this case, and it is a crime. And obviously, other crimes that occur in the community, there's value in those being reported, and law enforcement and government understanding the degree to which that activity occurs. I think, broadly, those principles apply in respect of ransomware payments. And as my colleague Chris mentioned, there's real value in the government understanding that threat picture and how often it is occurring in Australia.
Yeah, thanks very much, gentlemen. That's all I had, Chair.
Oh, okay. All right. Thanks, Mr. Gosling. Just one thing about discussions with the review board, but how do you manage or deal with the conflicts of interest? If you've got people on there from industry, how does one manage them with conflicts of interest from your end, let's say from the Business Council of Australia perspective? You wouldn't want a representative who might be a prime and then underneath know that their competitor might have a complaint being brought forward. How do you sort of propose that we deal with those conflicts of interests?
So I think in much the same way that they are in many similar organisations and mechanisms that have the possibility of commercially sensitive or other sensitive information shared. You have deeds of confidentiality. You have the ability for certain conflicted members to recuse themselves. You have, in this regard as well, kind of an honest broker in government to play the middleman. So there is that ability to mitigate those risks. So seeing that the US Cybersecurity Review Board has been operating successfully so far, I think that it's not an insurmountable challenge.
Okay. All right. Well, on that note, if there's nothing else from anyone else, can I say thank you very much to everyone. Thanks for your attendance, and obviously due to the very short time frame of this inquiry, any questions that were taken on notice, could you please get back to the Secretariat by 4 p.m. tomorrow, Canberra time, please. We'll also send you a copy of the transcript for you to review, and any errors you can make some requested changes. On that note, we'll suspend briefly and get ready for our next panel of witnesses, but we'll also have a very short break because I'm mindful that maybe a few people need to get a coffee or go to the bathroom. Thanks very much. We'll come back shortly. Okay, hello everyone. I now welcome representatives from Macquarie University, Universities Australia and the Australasian Higher Education Cybersecurity Service to give evidence at this public hearing today. Now, for the Hansard record, could I ask that you all state your full names and the capacity in which you appear today, and we'll start with Macquarie.
I'm Ross McLennan. I'm the Pro Vice Chancellor of Research Services at Macquarie University.
Universities Australia.
Thank you. Luke Shee, Chief Executive Officer of Universities Australia.
And the Australasian Higher Education Cybersecurity Service.
Thank you. I'm Nikki Peever, Director of Cybersecurity, Australasian Higher Education Cybersecurity Service.
Excellent. Now, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a very serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. So due to the very short time frame the committee is also working within, the very short time frame the committee is working within to complete its review, could you also please try and keep your answers as succinct as possible and provide any information to the best of your ability in the evidence today? And if you do require to provide anything on notice, we do ask that you do so by 4 p.m. tomorrow. Now, do you all have an opening statement? Okay.
Yes.
Statements from Macquarie University. Yeah. Okay. Now, we have a little bit of time, but could I ask if you could just keep it very brief? We might start with Macquarie, and then I'll go in the same order. But then Universities Australia, then Higher Education, Australasian Higher Education Cybersecurity Service. So off to Macquarie University first.
Thank you, Chair. And thank you very much for the opportunity to provide feedback and also to make this statement to the committee as part of this review of the 2024 Cybersecurity Legislative Package. My comments are provided to you in my capacity of the Chair of the University's Research Risk Review Committee, the Deputy Chair of the University's Countering Foreign Interference Working Group, and also wearing a hat as a Co-Chair of the Higher Education Innovation Research Group of the Trusted Information Sharing Network.
Very busy man.
Very busy man, like you, sir. We all have to wear lots of hats at all times. But our analysis of this legislative package is that it represents a sensible refinement that will provide the confidence to industry necessary for increasing proactive notification of cybersecurity incidents to the Commonwealth. And our submission focused on the impact of the limited use obligations, and I'd like to contain my remarks to observations on the notification mechanisms that currently exist between the university sector and the Commonwealth. So to provide some context, for universities that are members of the Defence Industry Security Programme, relevant security incidents must be notified to the Defence Industry Security Branch within 24 hours of discovery. Incidents that do not relate to defence industry research should be notified to ASIO via the Notifiable Incidents, Threats and Reportable Observations portal, NITRO, and universities must self-assess the thresholds at which they undertake notifications to NITRO. For example, Macquarie notifies via NITRO of any email campaigns that appear to be targeting researchers who have the potential to be working in areas that are aligned with critical technology. And it was only after a workshop which had been run by the Department of Education with the Countering Foreign Interference Coordination Centre that Macquarie realised that these notifications we were making were not also being received by the Australian Signals Directorate. And Macquarie has since changed its procedures so that in future it will notify identified email campaigns through to both NITRO and the ACSC. If an incident involves behaviour such as targeted phishing or scams that are received at an academic's personal device, then a notification could be made to Defence, to ScamWatch, NITRO or the ACSC depending on the context of this incident. And these cybersecurity incidents that affect institutions such as those contemplated by this legislative package are also notified to the ACSC. So the offices within universities that are responsible for managing these notifications are typically staffed by small teams. At Macquarie, it consists of just 2 full-time staff. And these teams are typically also responsible for a range of activities, including but not limited to export controls, sanctions, foreign influence transparency scheme, and Australia's Foreign Relations Act. Their work extends to due diligence, compliance, training, reporting, notifications, information sharing, and responding to government consultations. And at Macquarie, this team of 2 covers across 12 Commonwealth compliance programmes. There's currently no targeted financial support from the Australian government for these activities, compared to, for example, the research security category of Canada's Research Support Fund, or the creation of the Secure Centre by the US National Science Foundation. And it's within the context of cybersecurity, including how it pertains to countering foreign interference, that Australian universities are overseen by a complex suite of legislation and regulation. And Macquarie, like all universities, regularly engages on these matters with many government departments and the agencies that sit within them, including the Departments of Defence, Home Affairs, Foreign Affairs and Trade, Education, Industry, Science and Resources, and with ASIO Outreach. And each of these interactions is of itself incredibly valuable. However, what we look for is a coordinated whole-of-government approach to engagement, consultation and regulation, which will continue to deliver substantial benefits across the sector and for the security of the nation. And it's within this complex context that any additional information sharing mechanisms between government departments and agencies, such as those described within this legislation, are a welcome development. So to conclude, Macquarie is committed to partnering with world-leading organisations on advancing learning, teaching and research in Australia, and it's this research that benefits Australia and improves the lives of Australians. Secure and resilient international collaboration relies on a robust partnership between the research sector and the Commonwealth, and as such and through this lens, Macquarie is supportive of this legislative package and its intent. Thank you.
Thanks a lot, excuse me, Luke Sheehy, you've got the call. Sorry, a bit of water went the wrong way, mate. Sorry about that. You have the call.
All right. Thank you. My name is Luke Sheehy and I'm the Chief Executive Officer of Universities Australia, the peak body for Australia's 39 comprehensive universities. Can I start by acknowledging the traditional owners of the various lands where we are gathered on today and pay my respects to elders past and present. Thank you to the committee for the opportunity to be here today and to contribute to this important discussion. The higher education sector has a strong interest in the enhancement of cybersecurity protection in Australia. Our universities are highly engaged with this area, providing inputs into and sharing best practices on cybersecurity with forums, including the University Foreign Interference Task Force, the Council of Australasian University Directors of Information Technology, the Australasian Higher Education Cybersecurity Service, the Trusted Information Sharing Network, and the Enhancing Cybersecurity Across Australia's University project delivered by RMIT University. This has led to a significant increase in awareness and responsiveness to cybersecurity issues across the sector and a maturation of threat modelling, policies, procedures and governance within our universities. Continued engagement within the sector and with government has ensured that obligations under the SOCI Act have been comprehensively met, although there are areas that this legislation lack definitional and operational clarity. Universities Australia is broadly supportive of this legislative package, but we do have some concerns around the increased reporting obligations and duplicative requirements for universities contained in the legislation. Our submission outlines the impact of these additional measures on universities, as well as suggesting some ways the legislation can be improved to strengthen the framework. Chair, I'm happy to take questions and discuss any or all aspects of our submission to the inquiry. Thank you.
Excellent. Thank you very much. And the Australasian Higher Education Cybersecurity Service.
Thanks, Chair. So I'm grateful for the opportunity to present on behalf of the Australasian Higher Education Cybersecurity Service. We call it AHEX, let's save the mouthful, so I'll just refer to it as AHEX.
I love a good acronym.
Fabulous. So we believe a strong cyber-safe Australia is in all of our interests. I'm the Director of Cybersecurity at the Council of Australasian University Directors of Information Technology, CAUDIT, another acronym there. So we're an incorporated not-for-profit and we're owned by members across the sector. We have 69 members in total, but 55 of those are within Australia, and that's all of the Australian universities, a number of TAFEs, and also the leading research institutions such as CSIRO, DSTO, and Defence Learning. Our members are the Chief Information and Chief Digital Officers of these organisations and also their teams. And through our sector benchmarking, we identified cybersecurity was the top priority for these ICT leaders in 2018, and it's been their #1 priority ever since. As a result, AHEX was formed, so that includes all of the members of CAUDIT and also key partners within the sector. And we've taken a little bit of a different approach to cybersecurity. We support and uplift each other. We've got a very transparent and open sharing process. Our CISOs from all the universities, we meet monthly by telecon and then once a year in person. We have regular sharing and training webinars, a community of practice within the sector with 500 members. And we also use the model, for collective procurement to make savings, shared resources, threat intel, and just ongoing continual improvements across the cybersecurity programs. We also have cyber-focused benchmarking. So this year we connected that benchmarking with Canadian universities, and I think that it has enabled us to have a very comprehensive picture of the cybersecurity landscape of the sector, not only domestically, but also internationally. And that helps us really determine the focus areas of the sector. So we do believe that the way to make significant positive change is not necessarily through legislation, fines, or fear. We really appreciate the collective model as the key, a supportive, open and positive approach. And the government's done some fabulous work here across information sharing networks. So the TISN that Ross mentioned earlier, he and I co-chair our sector TISN group, the ASD Partner Program, AISA Outreach. They're just a few of the different sharing platforms. And we're really strong advocates for this. So regarding the cybersecurity legislative package itself, we largely support it. We appreciate the government's focus. There's a few minor recommendations in the written submission. We just think that these recommendations will improve the legislation, the reporting, and also future industry consultations just to increase effectiveness of the actual package. And more than happy to speak in further detail about any of these. So thank you once again. I appreciate the government and this committee's commitment to reform.
Excellent. Well, thank you to all three of you for appearing today, and you're happy to table your opening statement so we can have that to incorporate into Hansard. Yep. Thank you very much. That's a yes, so we'll do that. Now, with Macquarie University, could I just ask you, could you talk to the benefits of introducing a limited use obligation, and what would the benefits be for the university sector?
So as we indicated in the submission and hopefully covered in my opening remarks there, our observations are around making sure that there is a sharing of information across government departments. Our experience when we have been notifying various government departments of particular incidents which have occurred has been that we've gone in through one channel, and our assumption had initially been that then that information would be shared across all other relevant organisations and branches within government. That's not been the case, and we really want to look at it from two perspectives. One, to make sure that we're managing the regulatory burden on institutions in terms of reporting it once and that information being shared, but also making sure we can avoid any gaps within government. As has been alluded to through the opening statements, where we see incredible benefit in this space and looking at cybersecurity, countering and foreign interference and that broad context is where organisations and government departments are coming together, having an open sharing around what the challenges are and how we can address them so that we can make sure that any cyber incidents get nipped in the bud early and that information can quickly be shared through government departments and with other organisations across the sector.
And look, I'm glad you said what you just did. So can you also help me understand, is there any formal or informal network between the universities if there was an issue? Like, do you share information amongst yourselves?
So what has tended to happen, I mean, let's start with formal and then I'll get to the informal. I mean, in terms of the formal networks, there's the ARHEX group that Nikki's been talking to there, where the cybersecurity professionals come together. Also through the Trusted Information Sharing Network is a great mechanism where the different critical infrastructure sectors come together with various government departments to talk through particular issues. As a recent example, the CrowdStrike incident which happened a couple of months ago, the National Coordinating Mechanism bringing organisations together there to really learn in real time what the incident was, what the impacts were across the various sectors and how that could be mitigated into the future. So they're really formal networks which have come together for that cascading of information from the ground up, in addition to ARHEX, from the broader operation in the context of countering foreign interference and cybersecurity in the university sector. The TISN sector group around higher education, innovation and research is one element, but also informal networks which have grown up from the practitioners across universities of coming together to share best practice and, if anything, to provide a single voice to talk to government departments to raise those questions and to get that flow of information.
I don't know, Nikki, if you want to add anything to that from AHEC's perspective from what I've just asked?
Thank you, Chair. I think the CISO community are very big on sharing, and I won't name the universities themselves, but there was an incident a few years ago where a university was victim of a cyber attack, and pretty much within the week we're on a webinar sharing what happened and how to resolve it and mitigate. And so the other universities were then able to implement those mechanisms. Unfortunately, that first university had to suffer, but the other universities were able to adequately put in place mitigations to prevent, the same attack coming through. The CISOs do often get on webinars where they're allowed to share. There's often legal reasons and whatnot that may delay that particular process. But they are quite an open and transparent group. As Ross said, the TISN sector, it's an all hazards approach. It's not just cybersecurity specifically, but cyber's, I would say half of our meetings that we've had as it affects everyone, right?
Yes, it does affect everyone. Have you found that universities or the tertiary sector are still high risk, or the risk has moderated over recent times?
Yeah, great question. So from the benchmarking, we've seen the maturity increase over the last 4 years. We asked the CISOs in the benchmarking their own perspectives of the maturity of their institution at the current state and their optimism about the future as well as the past state. I understand it's self-reported, so it's maybe not always the best way to analyse, but it's an overall enthusiasm and optimism about the future, so much so that it's a 10-point scale, and I think they're up at 8 for the next 2 years. They're highly optimistic about the future of the sector, which I think is a great positive thing to see.
That's good. And in terms of the elements, what elements of the tools, kit and resource the government has provided in relation to the cybersecurity have your members found to be most useful?
I'm a big advocate of the NOC, so that's the National Office of Cybersecurity under Department of Home Affairs. They run webinars like tabletop exercises to help mitigate some of the connections with government if you're going through a cyber incident. They ran a tabletop with one of the universities, which we streamed via webinar to all of our members to get the benefit of the exercise. As you may know, Chair, these can be, 3-hour-long exercises one day. They can be quite time-consuming to do on your own. So I think the NOCs have been fabulous in some of their outreach work. ASIO outreach, I think maybe Ross or Luke may have different perspectives here, but they often will brief VCs and other members of the research community around foreign interference risk, as Ross mentioned as well, which is great.
Yeah. So, Luke, from University Australia's perspective, how could the government work more closely with the university sector in respect of developing cybersecurity capabilities?
Thanks, Senator. I would describe the ongoing relationship with the government in this regard as excellent, and there's been what I would probably describe over the last decade or so as increasing capability, but also changing culture, both in terms of the Commonwealth and, of course, our universities. And we've had more than one major cyber incidences at our universities. In fact, in my previous job, I had no email for 9 days at one point. So there's certainly a very strong culture of sharing information among our members, but also this growing necessity of regulation and intervention and collaboration between agencies, Commonwealth departments and our members through the forums that we've outlined in our submission and my opening statement and those present today, but also just generally building that cultural awareness of being cyber aware and the way that we acquire our information technology, infrastructure and software, and learning from all of those and ongoing and increased incidences of cyber. I think cyber awareness is clearly a prime issue for risk and governance across universities, and our councils are also aware of it, as are our managers, and we regularly engage with the Commonwealth. And I think the evolution of the interventions at a Commonwealth level and the engagement with our sector has been exemplary. And I'm often, asked about this with my contemporaries in other university peak bodies across the world, and they often look quite enviously to the collaborative and cooperative way that we work with our agencies in Australia, in the Australian university context.
Can I just turn to another matter that, just mindful of time, but another matter that we've also had some discussion about today, about why you are supportive of the introduction of the Cyber Incident Review Board, and what types of incidents do you see as being the most beneficial for the board to review if it's established?
Is that for me, Senator?
Yes, it is, Luke. Sorry. Yes, it is, mate.
Sorry. We think it's an evolution of where we've been in terms of the mix of responses that we have between the Commonwealth and the universities. As you can appreciate, universities have very differing structures, and some are big and large and complex. Some have various campuses that are scattered across different large geographic areas. So it's always good to have a coordinating agency, and we support the Cyber Incident Review Board and expert panel. And we think it will complement the current arrangements we have, including UFIT and ASIO outreach and all of the other things that we've outlined in our submission. What we would say is just to caution about layering new things on top of existing things, and that we can continue to look at the regulatory impost and the capacity within our universities to deliver the right level of engagement with the Commonwealth on this issue.
Ross, did you have something to add to that question I've asked?
And just to echo the comments which you've heard in earlier panels about making sure that there is the opportunity for that board to tap into the expertise in universities around cybersecurity, both in terms of the practical implementation of it, but also in terms of the research agenda, which is looking at what the next wave of defence against cyber attack can be, but also how to train the workforce. And I know that there's many universities, including Macquarie University, that are very strong in terms of that formal bachelor's degree and beyond training, but also that executive education of working with colleagues who are in a broad suite of industries to raise their resilience levels and the expertise which individuals in those companies have.
Yeah, Nikki, did you want to add? And I think you might have a different take on this. Is that right?
No, not at all. I do agree with Luke and Ross. Yeah. I know several witnesses today have mentioned the CSRB in the US, so I do think it's really important to find the right balance. I think the US CRB has a 7 to 8 public versus private type of makeup, and I do think it's important to have your SMEs if it's a small business incident. So it really depends on the type of incident that you're seeing as to who may provide the most input. Just say you're looking at a new malware strain, you might want to get a leading academic who's conducting research into that particular strain, and they would be someone that might come in through the expert panel. I also think that this board is a crucial mechanism for sort of bridging the gap between how quickly technology evolves versus the legal system is maybe not so quick. So it's going to provide that, so that mechanisms for lessons learned and adapting to things as technology is changing.
There was a bit of discussion today about the composition, membership. Do you think there should be just APS staff on it, or do you think there needs to be a mixture? I mean, there's this expert sort of advisory panel or group that sits underneath, and when needed, I guess the board itself could tap into those expertise. Is the current structure proposed in the legislation sufficient from your end?
I think the later of what you suggested, so a mixture of public and private. The CSRB, seems to be successful by all measures that they've kind of implemented for that, and they do have a mixture. Why reinvent something that appears to be quite successful and working? And I think it's just important for that alternate perspective as part of that review board. We have noted in our written report, though, that open, transparent, and independent representation on that board. So, as others have suggested in the day, no conflicts of interest and commercial advantage as being a part of that particular board or expert panel.
Luke, did you have anything to add about the composition?
We'd certainly echo that, and we'd also reflect on where we've had the best approaches to these things is where there's collaboration between government and either the university community or the business community more widely. The more we can co-design regulatory interventions or approaches, the better. So I would have, a level of concern if it was limited just to public servants. While I am a son of a public servant, I have deep respect for them. I think it's important to have a breadth of experience and perspectives in these bodies.
And I know earlier on you mentioned about the engagement with government. So hoping you might be able to place on the record how you would characterise the engagement with government since the cybersecurity strategy was unveiled back in December 2023.
Senator, well, I've found on both sides of politics the engagement on this issue has been excellent. There is an enormous level of bipartisanship, and particularly through this committee, I might add, there's been an excellent dialogue between our sector and the Commonwealth and the Parliament, and it continues in this Parliament, and I hope it will continue into the next Parliament. We are, as I said earlier, some of my colleagues at other university groupings in other countries are envious of the way that we deal with our agencies at a Commonwealth level with a collaborative approach, and so I hope it continues. And I've been very pleased, and as our sector representative body, on behalf of my members, I think we're generally very pleased with the approach that's been taken in the development of these legislative interventions. What I would say is we've had very little time on this one in particular, so it would be remiss of me not to mention the constrained time to respond to it. But we understand the emergence of various threats that are out of our control, so we obviously work with the Commonwealth and we appreciate the level of engagement.
Yes, well, we've been very efficient, this committee, to try and get a report back to the Parliament for adoption later this year. But Ross, did you have anything to add on that?
Just to echo Luke's comments there, I mean, my experience of this piece of legislation and the broad package of activity that's going on across this space is that all government departments over the last 5 years have really increased the amount of consultation which they conduct, and not only around pieces of legislation, but importantly around the implementation. I think the ongoing challenge is to make sure that we have the legislative environment which is incredibly strong, but in a way which that regulatory burden can be managed, because universities do not have huge teams to manage this process, and we want to make sure that we can put as much attention, if not more attention, into the delivery and the due diligence and the control as we do into that consultation. So it's often the same people who have to manage both of those activities.
Yeah, that's all right. Now, Nikki, in your opening statement, you mentioned, I think towards the end, there may have been some other issues that you may have had with the package, but overall you were supportive. Did you want to just...
so regarding the consultation itself, Chair, I agree with Luke and Ross. Love the engagement with government, the access to government. It is fabulous. The 2-week turnaround for written submissions of this package could be improved. I know you're hoping to give the nation an early Christmas present, but it doesn't provide ample opportunity, for deep look and review of the actual package itself. That would be my only, negative around the process.
We have an excellent secretariat who do fantastic work, and some are sitting next to me right now, and they will do what they need to do and make sure we keep Australia safe. So, look, on that note, I'm going to hand over to the Deputy Chair, Mr. Wallace, for some questions.
Thanks, Chair. Thanks, everybody, for your attendance this afternoon. I appreciate it's starting to get a little late in the day, but can I just ask my first series of questions to Mr. Sheehy, just around the concerns that you indicated in your submissions around the issue of duplication of reporting, particularly in relation to the security of critical infrastructure requirements vis-a-vis these new requirements, and how you think we should be dealing with that issue.
Thanks very much.
I don't think we've dealt with that issue yet, have we?
No, I did refer to it in passing, but I'm happy to answer your question, of course. We have obviously in consultation with our members, they've let us know that they already have multiple contemporaneous incident reporting requirements, such as through the Australian Signals Directorate, Australian Cybersecurity Centre, the Office for the Australian Information Commissioner, the University Foreign Interference Task Force, and of course state-based organisations. It's my understanding that a single entry reporting portal made by the government would be beneficial to the higher education sector. And if I can, in our sector, there is an emerging and ongoing regulatory burden that is not just isolated to this issue, but on many issues. And we're always looking for a kind of risk-based and proportionate approach to regulation. The risk is layering another regulatory system on a pre-existing one without looking to see what is fit for purpose. So we just caution about that. But generally in this space, there's already a lot happening. That's out of necessity. We understand that necessity, but we just make sure that we continue to look at it and monitor it for its impost on the sector. I think, as my colleague from Macquarie University has rightly outlined, that we have limited scope, capability and expertise within our institutions to respond to these regulatory requirements. So we have to make sure that we're not stretching our resources too thin.
Okay, thank you. Can I go to Ms. Peaver? In your submissions, you talk about concerns you have about the independence of the CIRB, specifically in relation to the Minister approving the terms of reference. That's an issue that I've taken up today with a number of witnesses. Your concerns, as I understand it from your submissions, that could be seen to be impacting upon the perceived independence of the CIRB?
100%. And I think that it doesn't add any value to the legislation and the process of forming the review process, and the legislation is just as strong without that particular requirement.
Yeah. Do you see any utility in it?
No, and our members didn't have much further to say other than, Section 2A of the proposed legislation is more than sufficient to commence the process. You're looking at potential delays and things because you're adding additional mechanisms, in order to commence the incident, and these things are very fast moving, right? So you want the review to occur in enough time, right, to make sure that you've got all the information you need.
Yeah. Can I stay with you, please, Ms. Peaver?
Sure.
In your recommendations, you say that the government should reword Part 3 of the Cybersecurity Bill, both in the heading and as documented throughout the section, to ensure accuracy and clarity of the bill intention. Mm-hmm. Do you want to speak to that?
Yeah, absolutely. So the bill itself, the title is ransomware. So ransomware itself is a malware strain that is then deployed, encrypts the network. We've actually seen, and industry stats say, ransomware itself is declining over the past year. What we're seeing increase rapidly is data exfiltration on its own, or maybe double extortion, so ransomware and double extortion. So, as I mentioned earlier, technology moves fast, legal not so much. You're looking at kind of ethics to play in the middle to catch up, and criminals probably aren't known for their morals and ethics. So any legislation pertaining to criminal behaviour or technology, it really needs to be forward-thinking and looking at the threats that are emerging. Ransomware itself, you're limiting it. The bill does speak to, it's capturing both a ransom demand and a ransom payment, whereas the heading is looking at just ransomware, and they're two very different things. And throughout the day, I've heard people use them incorrectly. So I think it needs to be very clear for people to understand what their obligations are and capture those potential threats in future. I think you are hoping to look at ransom of any kind that pertains to a cyber incident, and so that should be clear and say that in the title.
So what would you suggest that it be called?
Ransom demand and payment. So remove the where, W-A-R-E.
Another acronym.
Yeah, kind of.
What do they call them? RDP. ARE?
Yeah. As I understand, so Optus and Medibank neither had ransomware deployment in either of their cases, and so thus, ransomware isn't pertinent into one of our nation's biggest breaches, but because of these breaches, that's what's led to this reform, and so you'd be hoping to capture that actual ransom itself. Further to that, I do think that before anyone makes payment, they should engage the government. So at that demand phase, that's a really important place to step in.
You also talk about in your recommendations that there should be an encouragement of industry to first engage government prior to paying a cybersecurity incident ransom demand or any criminal-related ransom demand. We've heard contrary evidence today that would just create too much of an impost on entities that are required to comply with this. That, as I understand their evidence was that that would be too onerous, and that the requirement should only come after payment. Why do you hold your position, and what do you say about the alternative?
Yes, that's a great question. So the sector itself, through our collaborative approach, there were mixed views on should ransoms be banned, should they just be, notified to government when they're paid. Some obviously people tend to be very strong either way, and I think there are outliers and cases where a ransom should be paid, but as much as we can encourage people not to pay ransoms, we should not be paying monies to criminals, right? You're encouraging ongoing behaviour, and as much as that can happen, we should do that. So that's why I do think that at the point of demand, it should be notified to government. Obviously, there was discussion around the size of the organisation and what that would look like in practice to not cause any more reporting obligations that are unnecessary. But, there's cases of people paying ransoms or having demands monthly, and they're just doing it like a subscription basis, right? And they're small, they don't know any better. And we need to get on top of that because that's, again, we've spoken all about education throughout the day today, but that's something that the government could definitely help with and help support people that are stuck in those type of situations.
I'm not quite sure I still understand why you think that the requirement should be triggered upon demand rather than payment.
To avoid people paying the ransom as often as possible. I think.
But why would that follow, though? Are you suggesting that if people had a requirement to report, that then government would say, well, hang on a minute, don't pay?
Yeah, and potentially connect them with the right people and review the situation to see if the payment is acceptable or not. Is it an outlier situation, loss of life, things like that?
Government's
instead
not
of
going to
people
say
taking the easy route. You don't think?
Oh, well, I mean, my experience with government is that they, and it's not just the red government, doesn't matter whether it's red or blue, governments don't tend to sort of want to put their necks on the chopping block and give advice to businesses. That's my experience anyway.
Yeah, absolutely. It may
35 years in business.
Yeah, well, it may also be around the education. So people should be aware that if they then pay, what the potential repercussions are. So, they're unlikely to get their data back, for example. It's still likely to be double extortion and another payment be demanded. So even whether it's not the government taking a firm position on this, which I understand might be contentious, but it may be just providing that education at that point.
Can I ask the other members of the panel, thanks Ms Peaver, I'll come back to you in a moment. Can I ask other members of the panel their views on whether the mandatory reporting should be triggered at the point of demand or at the point of payment?
I mean, from my perspective, and I think to come back to some comments which were made earlier, is that this is a sector which is highly interconnected and highly collaborative, and across a whole range of different areas where we see the advantage and our request of government is to be able to share information around issues such as this with one another, to be able to identify when a small incursion at one university is part of a broader pattern which is happening simultaneously across many institutions, which would then of course change the risk and the risk profile and how we can work with various government agencies to be able to combat that. And I think the initiative and the conversations that I've been part of, and not a subject matter expert at all, that sort of through RHEX is where our expertise lies across the sector. But my experience is that being able to identify what's happening across the sector whilst it's still happening allows us to be much more nuanced around how we respond to it. If the reporting only happens after a ransom has been paid and after the whole issue has been closed, if there's also other universities which are going through something at the same time, we miss the opportunity to learn and to make some smart decisions across the sector.
So what I want to invite you to do is think beyond the parameters of university world and think about how this could impact upon small businesses, for example, unless you specifically wanted a requirement specific to universities, but I'm imagining we don't want that. It's all well and good for, and I don't mean this disrespectfully, but it's all well and good for a university to say that. But take your university cap off and think, well, if I was a plumber or an electrician or a butcher, would I want this onerous requirement every time I got a demand?
I'm no expert of working in that sector, so I wouldn't be able to provide a detailed comment. I may turn it round the other way and go, wouldn't it be of benefit to government to know that there are thousands of organisations that are being impacted or held hostage in the same way at the same time, to be able to look across the nation to be able to intervene, rather than important to the individual and to the organisation, a single institution having a isolated ransom attack.
Mm-hmm. Thank you, Mr. Shee.
Thank you. Obviously, I'd echo the comments from Ross around the university sector, but reflecting on the SME context, I mean, we're large, complex organisations, many of which are the same size as Commonwealth departments, if not bigger. So sharing information and understanding the nature and frequency of cyber incidents is probably good for us. But I do appreciate your point. We foster and support many SMEs in our sector, and Australia is an SME economy. And I think there is some sort of regulatory impost that should be considered for SMEs. But I'm standing here representing 39 universities that support 250,000 jobs, and there's $51 billion to the Australian economy through international education for now. So I'm not quite sure if I'm the best spokesperson for SMEs, but I do have an affinity to SMEs, having run one myself previously. And, you have to balance the regulatory impost to actually succeed in business. So, that's something that the government and this committee should consider on behalf of SMEs.
Yeah, thank you. I did want to talk to you all, or at least invite a conversation around, I think are we all in agreement, or are the three of you in agreement about the importance of the makeup of the CIRB being not just sat upon by public servants? Does anyone want to speak against that concept?
I'll just step in on that. I think we covered that off with the chair, but certainly just echo the fact that we have a lot of respect for the public service, but we think the best approach is to be collaborative between sector representatives with an open and transparent process for appointments.
Yeah, and how you deal with conflicts.
Yeah, absolutely.
Yeah, good. I just wanted to make sure that you were all on the same, singing from the same hymn sheet. Great. Thank you, Chair. That's all I have.
Ooh, excellent. Jeez, that's very efficient of you, Deputy Chair.
Mr. Efficiency, they call me.
Wow. Okay, we'll leave it at that. On that note, can I say thank you very much to Nikki, Luke and Ross for your time this afternoon. If there are no other questions from committee members, I will just remind our witnesses that given the very short, efficient timeframe of this inquiry, if you have any information or answers that you need to come back to me or Mr. Wallace on, please do so by 4 p.m. tomorrow, and that's 4 p.m. Canberra time tomorrow, on Friday the 1st of November. We'll also send you an exclusive transcript of today's proceedings, so you can review it and make any additions make any changes to any errors.
Signed by the chair, autographed by the chair.
Exactly, a limited edition. And can I thank you again for making time and making the time to also make a submission to this very important matter. On that note, everyone, there being no further witnesses, I will declare this public hearing closed. And if I could just also ask committee members just to remain online